Yes. Any original side mentioning? Okay. Listed matter, item number 1 to be mentioned, Dalhousie Exchange and another versus Life Insurance Corporation of India and others.
Please, your lordship.
Yes, you argued. Other side is to argue. Probably.
My lord, on the last occasion, my lord, we have concluded our argument.
All of you have concluded. So today for filing of written notes.
File the written notes by the, my lord, petitioner.
My lord, I'm appearing on behalf of the petitioner.
You had filed your written notes on the last occasion.
My lord.
What written notes, sir? What is tentative?
My lord, these are the
written-
final written notes.
Why are you placing this? What is a tentative written note you are handing over to a court of law? Are you joking with the court? What's tentative?
My lord,
Understand this. What is this practice?
I apologize, my lord. I'll file it in the course of the day.
You're handing over a copy of an argument. You are saying it's tentative. What do you mean by that? Learned counsel for the respondent, learned counsel for the petitioner seeks to hand over a tentative single imperative মধ্যে written notes of arguments. Full stop. Such written notes are refused. Full stop. Learned counsel is directed to file a proper written notes of arguments during the course of the day. Hearing is concluded. Judgment is reserved.
My lord, we have not. My lord,
I've closed your argument.
my lord, we have not favored with the copy of their written notes, my lord.
They will give it.
I'm grateful, your lordship.
You have given your copy to them.
My lord, I have. I have already handed over, my lord, prior to my lord placing
If they
the.
don't give by today, then just mention it tomorrow when I
My lord,
sit in the
my
office.
lord.
Just
I'm-
mention it.
I'm
Yes.
grateful.
Follow me.
Item number 2, AP 2 of 2003, Sanjay Kumar Bhagat.
Yes.
Please, your lordship.
Lordship,
This was for correction. Or?
my lord, this is for substitution of the
Oh,
learned arbitrator. It's coming up for the second time for substitution. Lordship,
For
substitution of the learned arbitrator. Because
again.
My lord,
Oh,
I-
so that's
I am
what.
Yes,
told-
my lord.
Yes.
My lord, this time the learned arbitrator appointed had appeared for the petitioner in a connected
Common
matter.
name. Any common name.
My lord,
Not
that is, my lord, I believe my learned friend has 3 names. We have,
if
my lord,
agree on
three other names.
the others.
And
Give
my
the
lord-
names.
Lordship, if we may put in a.
I leave it to your lordship, my lord, because
No, I don't know who is not appearing in this matter because everybody appears to be appearing in some stage.
your otherwise,
What is the
I leave it
valuation?
to your lordship.
More than 10 crores.
What is the valuation?
More than 10
Approx-
crores,
The,
Lordship.
my lord, it is not really 10 crores. 10 crores is the
Lordship,
valuation
it
of the
is 10 crores.
property.
It is 10 crores.
Rentals in issue is
What is
not.
the valuation of the dispute? I mean,
Lordship, roughly.
My lord,
10 crores.
valuation
The
of the
proper-
dispute
the
is
dispute is regard to distribution.
with regard
of
to
assets of
rents. So maybe, my lord,
No,
it
not with the
lacks.
rents, Lordship. It's with regard to the assets of the partnership firm as well. So it would amount to cumulative amount of greater.
Or
than
if it
10
can be, my lord, any other name which falls from your lordship, my lord, not in the list.
these are all good names actually.
I agree, my lord. The only difficulty is one party is, my lord, suggesting 3 names, my lord, the other party is suggesting another 3 names, and they could not come to a consensus. So, my lord, I will beseech your lordship, if my lord, your lordship,
Lordship,
appoints
my
anyone, my lord.
Lordship, my instructions are that talks have been held with Mr. Jishnu Chaudhary, and he did agree on the 3 names that we have suggested.
My instructions are otherwise. My instructions are, my lord, that. But it is very embarrassing, my lord. I will not make any submission. I leave it to your lordship.
We'll leave it to your Lordship.
কিছু বলবে না সিএবি ম্যাটারে কিছু বলা হবে
In normal course, all these names are in my list also. So normal list from which I. So I have to think of somebody else than these. Very like order to record. It is submitted by learned counsel for the parties that the last appointed arbitrator, Mr. Sarvopriya Mukherjee, has declined.
Lordship,
Mr.
Mr. Oyon,
Mr. Oyan Banerjee was subsequently appointed.
Mr. Oyon Banerjee, sorry. Oyon Banerjee has declined to accept the office of arbitrator since he had apparently appeared for one of the parties at some stage. Full stop. Next. Such view of the matter. Let the order dated April 24, 2023 stand modified to the effect that blank রেখে a former judge of this court is appointed as the sole arbitrator to resolve the dispute between the parties, subject to obtaining a consent stroke declaration under section 12 of the 1996 Act. I'll put in the name, I'll think over it.
I'm
These people I'll have to exclude probably.
Grateful, Lordship.
Deeply obliged.
Because none of you agree on these.
Grateful.
Well, in item number one request, we have already submitted all judgments. Now, maybe my advocate take back and compile it along with the notes of argument so that it may convenient to your lordship.
You filed it, I've closed arguments.
Very well, very well.
And I'm filing my notes on arguments. The final one is ready. I'm filing it. It was sent. Tentative copy.
You're
has been-
playing with the tentative written notes and all these things, Mr.
No, my lord. I'm
On two occasions, you,
I beg
said
to
that
be
you are ready
excused
with the tentative notes and you're filing a tentative note in court.
no, my lord. That was not the instruction. I've sent the final note yesterday evening, my lord. There's some miscommunication, my lord. Kindly, my lord.
It was written tentative that she has the gumption to file that in court.
She hasn't even gone through it, my lord. The final notes I've sent
Anyway, not
yesterday.
her fault probably, but she was instructed, but she has filed, done it. That's why he refused, recorded an order on that. The practice should be
No,
deprecated, you said.
Definitely. It's and it's
So
my
file
fault.
it during the course of that, please give a copy to them. What is this hide and seek?
No hide and seek, my lord. No hide
At
and
no
seek.
stage of time you have given them a copy. They have repeatedly
No,
asked,
notes-
you have asked, they are
notes I
not
have
giving,
shared.
you are not giving. What is this?
No, no, we have
It's a fair game, Mr. Banerjee.
My lord, notes I have shared. Note that.
So give the final copy to them.
Final copy also
This-
I'll give. The earlier notes also I shared, my lord.
No,
After
this
that,
note, the final notes,
Yes,
please
yes,
give a copy.
definitely.
Very good. File it during the course of the day. I've given you leave, I've closed arguments.
Deeply obliged, my lord.
Thank
Grateful.
New motions, item number 3, Bharti Devi and others versus Atulya Diagnostics. LLP
My
and
lord,
others.
this is my application.
Yes.
But my lord, in this, it
What about
involves-
service on the respondent?
Yes, my lord, that has been completed by way of newspaper publication.
Oh, there was a direction.
Yes, my lord.
Ask, very good. Yes.
My lord, may I file the affidavit of service?
Right.
My lord, in this, there is a lease agreement, my lord, which is insufficiently stamped and not registered. My lord, in view of the judgment of the Honorable Supreme Court which came out, I would be praying for an adjournment, my lord, to consider and come back.
Affidavits of service filed today be kept on record. Full stop. Learned counsel for the petitioner seeks an adjournment to take appropriate instructions in the matter. Full stop. Accordingly, let the matter stand over till when should I keep it?
One-
Next week.
One weekend.
Very well. Shall next be listed on May 4, 2023, 4th May.
Great.
Item number 4, RSM Constructions versus Texmaco Rail and Engineering Limited.
Pass over in the first call.
Item number 5, RSM Construction, Texmaco. Item number 6, Dinesh Kumar Pandit versus the principal Hindi.
For my lord, 1 day's accommodation, my lord, Mr. Mr.
One day's accommodation.
Yes, my lord.
Please, my
On the
lords, I
prayer of-
appeal
you're
for
for the
the
petitioner?
respondent.
I'm for the petition.
On the prayer of the petitioner, the matter is adjourned for the day.
My lords, may I request for Monday, my lords? I have some personal difficulty. I'm for the respondent.
তাহলে ওই অর্ডারটা একটু কেটে দিন।
I'm
On
grateful.
pair of parties, the matter is adjourned till May 2, 2023, Tuesday.
I'm grateful, your lordship.
Item number 7,
My application.
Yes, Mr. Banerjee, what
I'm
is
for
it?
the respondent, madam.
You're for the respondent?
Yes, madam.
I'm for the
To file
petitioner,
my
not-
Gokalatnam and my lord competence.
Affidavit of service.
Gokalatnam, you have to file in the department. No, no, file it in the department, it will be lost. You will be in difficulty later on.
Madam.
Yes.
Short matter, my lord. I don't intend to trouble your lordship with anything here. Dispute
Do
between.
you
two-
object?
Well, one thing,
Arbitration.
I'm not objecting. Kindly, my lord, there, section 21 notice, page 13, page 76 H.
Page 13,
No, page 76 H, annexure H.
annexure H,
H,
page
76.
yes.
Two issues, my lord. One, settlement of accounts of addons payable. No account has been annexed here. No account has been sub to us. What is the accounts? I don't know.
You're not required to under 21.
Next, exist of addendum dated 23rd, 7, 1990. That document has not been annexed here.
But in fact,
Section 21, do they need to?
I don't.
And one more thing,
Yes.
one document they have annexed in last, that should not be annexed a part of this proceeding, but after commencement, they have written this, the 12th, last J82. 82 page. Page 82 annexure J, that is April 12, 2023. That is after comment, the 13th February 2023. Their commencement. Commencement means A, B, C, D, then commence. After commencement, it should go to the shoulder of the commencement. After they are reading this letter.
After commencement of what? The arbitral.
Is to section 21 notice.
So what is your argument on this, J? What do you say? This should be?
I should be given to reply that it has come after commencement. Commencement, there are 2
This
points.
is not a part of the pleading or anything. Section 11, I cannot even decide on the merits,
Right.
which is very settled now. Well, so what is the valuation, approximate valuation of the dispute, Mr. Banerjee?
It will be about 50 lakhs.
50.
50. No, 50.
50 lakhs, where I was stated.
Why will I?
Very well.
This is for the purpose of appointing arbitrators. No, not for any other
No
purpose.
account has been sent to us.
The learned counsel for the petitioner contends that after a dispute having arisen between the parties within the scope of the arbitration clause in the concerned contract, a reference was made by the petitioner under section 21 of the Arbitration and Conciliation Act 1996 on February 13, 2023, full-stop, in view of no response thereto and or agreement with regard to the appointment of arbitrator, the present application has been moved. Full-stop, next paragraph.
Given reply.
There is a response. They have denied my nomination.
আচ্ছা, in view of no response যে কথাটা বলেছি,
Next
no
chapter,
response
page 80.
and কেটে no response and এটা strike out করে দিন, no response and এইটুকুনি strike out করে দিন, বাকিটা থাকবে, no agreement regarding it. Learned counsel appearing for the respondents submits that the allegations made in the notice under section 21 of the 1996 Act are not specific. Full-stop, moreover, it is submitted that a document dated April 12, 2023, which has been issued apparently after the commencement of the arbitral proceeding, has been annexed to the present application. Full-stop, the same cannot be looked into for the purpose of the dispute, it is submitted, without giving an opportunity of rebuttal being given to the respondent. Full-stop, next para. As regards the objections taken, the notice under section 21 of the 1996 Act need not contain the specific details or particulars of the pleadings, since the same is merely for the purpose of invocation of the arbitration clause. Full-stop. As regards the second objection, the court under section 11 of the 1996 Act is not sitting on the disposal of the merits of the matter, and as such, the documents annexed to the present application are not germane for adjudication of the issue before the arbitrator. Full-stop. However, since there is an arbitration clause which is apparently which is prima facie valid and the dispute falls within the scope of the said clause, the matter ought to be referred to an arbitrator. Full-stop. Accordingly, AP 230 of 2023 is allowed, thereby appointing some advocate of this court.
Ideally, my lord, with 50 lakhs.
I'll appoint some of them are my friends. That's the difficulty.
That's all right.
No.
I don't think that will. Well, a lot of members would be.
That is the difficulty. So many members.
It has to
Very well,
happen.
very well, very well. Right, you're right. Appointing Mr. Sharup Pal, because I know that person is unbiased, at least. An advocate of this court as an arbitrator to resolve the dispute between the parties. Full-stop. This order shall be subject to obtaining consent, declaration under section 12 of the Arbitration and Conciliation Act 1996. His phone number I'll be finding out and putting it in there.
Action motion, item number 8.
My application. my lord.
Yes.
My application, my lord, Mr. Mitra was on the other side. We had indicated that we'll come with a suggested order. This is the suggested order, my lord. I don't mind, but
So only the operative part, Lordship, they will have to.
Look, there is only one thing. Can I have a look at the order?
After kya could be.
No, কিছু নয়, আমার coffee type আছে। Thank you.
For the I'm birthday did for the.
And the only thing your lordship will find that B, there is reference to an order passed in a FMAT. Now there is a party to the FMAT who's not a party to the arbitration agreement.
B, I won't put in my order.
That's right, my lord.
B, Mr. Mitra.
B, your lordship can't put in a section 11.
No, because
I don't need any order.
because I'm withdrawing the suit. Because I'm withdrawing the suit. I'm withdrawing the suit. There is an order of status quo passed in the suit. Now that can also be a section 9 because of the judgment's interim order there. So we had agreed that whatever order is subsisting today, one is in their section 9 and one is in the suit. Both will continue till the disposal of the arbitration or subject to further orders of the
So
arbitration.
you have to enter that agreement, Mr. Mitra, out of court. But I cannot put it in my section 11 order. Section 11, I cannot put this in.
These orders,
Unless you agree, both of you agree.
Yes, yes,
Even
this
if you agree, in
this
fact,
is agreed order, man. This is
probably,
agreed.
Mr. Mitra, this is beyond the scope of section 11. You cannot say this.
Because
I can
there's-
record both of your submissions that you were saying this, but I
Which
cannot.
is
It
why
cannot be a
in the
part of this.
suggested order that I had prepared,
It
and
was
I
by
shared-
consent. It was by-
I had
If
said
both of
that
you have
we
different
undertake.
suggested orders, then we
No,
can. this is
not
fine.
that. I had said that we undertake to abide by, to maintain status quo till 30 days from. So that undertaking, your lordship could have recorded and sent it.
But
That could have
Very
been
well,
valid.
Very well.
then we can prepare it in that form, undertaking form. But the only thing is that he is 2 of the 3 owners. Third owner is not giving the undertaking.
Remains free.
So that way, my lord, that order covers everybody. Because who's the second?
Mitra, even if you argue on merits, I'll refuse that prayer.
No, on merits, this is the
Merits of the section 11. That is what I'm saying.
yes, 11 merits. Of course, I can't
Merits
ask
and
for the-
demerits depend on the arbitration clause only.
Yes, so section 11 merits, of course, I can ask.
That is what I precisely want to tell.
Lordship, then, Lordship, can we do something? My lord?
Yes.
In the form
Let it
of-
not be an agreed order, I'll pass my order. I'm passing my order right now. I'll appoint an arbitrator, not in agreed this form. Section 9 order will continue, I cannot. That I cannot.
By consent, Lordship, that I think is by consent.
By
there-
consent, no, I cannot be conferred jurisdiction.
Parties consent, like in a probate case. Where,
That is what I suggested.
no, like in a probate case, the consent.
probate
comes-
case and section 11,
Well,
Mr.
civil level. What I'm saying is that by settlement, they can't be granted probate. So probate case, only probate can be granted. So the way, so when the parties settle amongst themselves, that can't be a probate. So the courts, what they do, can appear also. in
Mr.
the-
Mitra, within the contemplation of order 23, the court can pass an order on consent on a property which is not the subject matter of the suit, definitely, but not on an inherent jurisdiction which the court lacks. In a civil suit between, suppose, husband and wife with regard to property. Now, in that, suppose title is sought. In that, can the court pass an order even if the parties agree that yes, we agree to divorce? We cannot, because we don't have inherent jurisdiction to do that. Regarding subject matter property, yes, always.
What can be
You can
done?
agree on some third subject matter.
What
Section
can
11
be
is
done is like a probate case,
Yes.
the terms are kept on record and the petition is disposed of by withdrawal. And the terms are simply kept on record. That is.
I can at best, Mr. Mitra, record your submissions made on instruction, and you keep your own instructions. You keep copies of this. I'll give you 1 day's time. Both of you take copies of this. Keep those with your clients or advocates on record, so that it's settled that you're agreed. But it cannot be a suggested order on
No,
section
only-
11. I can record that parties have agreed out of court,
That
settled
I
out of
think will
court
suffice.
on this point only.
That will suffice.
No, not that. No, I
Otherwise, I cannot.
correct. No, I indicated paragraph B because I wanted to complicate it a bit further. That's why I indicated paragraph
Naturally,
B.
you're there for that.
Yeah. No.
Yes.
That B, that FMAT order, your lordship will find it refers to, there's a party who's not a party to the arbitration agreement.
No, I'm withdrawing the suit because I have filed a suit
Withdrawing the
against third
suit.
party.
But my difficulty is that with this order there,
Hmm.
with reference to the order in the FMAT,
Then why did you agree to
Which is
this?
why-
Why are you saying
which
it
is
now?
why I had,
Why are you saying
no,
it
because
now?
I wanted to make this submission
Sir,
apropos
this
a
is
third
not
party to the
proper.
arbitration agreement.
Mr.
that
Banerjee
much,
and
your
Mr.
lordship
Mitra, you see this, I will not make a part of my order under section 11, but if you can couch it in some other language, this will not be a part of, it cannot be a suggested order. You
Very
can agree between yourself on this only, and you can have an agreement, you can file a copy. At best, I can keep that order,
That's what.
but that has to be out of court then. No,
Yes.
no, out of this section 11.
Only the kept on record.
It will be kept on record. I
That-
can keep it on record.
I think
Mr.
that
Banerjee.
will suffice.
I can keep it on record. If both parties are on their bona fides, then I can keep it on record. I'll say that they have agreed between themselves. That is out of court. But the order of appointment of arbitrator is obviously under
That is
section.
exactly
Then
what
at
my
the
lord.
best I can
I
do that.
don't mind this order being there, that I'll agree, but.
No, I mind.
No, that's, I agree. That's why I
Cannot do
indicated
this.
paragraph B.
Agreed order, even if
It
you
will
agree,
become
cannot do this.
contentious apropos the third party. If Mr. Mitro agrees,
So then you.
Cannot be apropos third party. That's precisely what I'm trying to point out.
that is right. which
You
is why
can
I
agree
wanted to
between
point
yourselves,
that out.
whoever are agreeing, please agree to your heart's content. I can keep a document on record saying that you have agreed out of court.
Then-
But the court will not be a made party to that illegality. Come back tomorrow.
Well.
Agree between yourselves tomorrow, or I'll
Now I
keep
would
it
like
on
it
one.
to be signed by Mr. Banerjee will.
Yes, please have it signed by both
agree
sides and
something
I'll
and
do this.
say
Mr. Banerjee,
something.
you also issue.
There was never
Unless
any
you
disagreement
will
on
be in
this.
difficulty later on.
Yes, man.
You will be in difficulty.
Very well.
Why take the risk?
No,
If
I
your
don't
client said-
take that risk.
Don't.
But with this reference
I
to
keep it on
FME,
Monday?
Mr. Mitro will bring in a third party.
Should I
That's
keep it on
what I
Monday?
don't want.
That you cannot. You have to spell it out.
Argue today.
Yes.
Ajke I'm not ready to argue.
Very well. Then I'll just sit with him once.
When should I keep it tomorrow?
Day after.
Day
Tomorrow is it's
Monday,
a,
that's
tomorrow it should be.
Let it be on the
Yes,
list.
it was
Oh, my junior is not there tomorrow.
Mr. Junior is not there. When will she back? Mr. Because Mitra.
No, she's there. Mr. Shadudi Bhattacharya, he has a matter in Delhi, I know. He has got tomorrow.
So when should I keep it? Tell me a date.
On Monday.
Monday. The suggested order sought to be proposed by parties cannot be accepted since there are certain issues included in the same which, according to the court, do not fall within the purview of section 11 of the 1996 Act. Full-stop as such, the said suggestion is not accepted. Full-stop, learned counsel for the parties are requested to explore alternative possibilities of amicably having an agreement on the issues sought to be made a part of this order, out of court, and return to court by handing over a copy of that out of court settlement, if arrived. Full stop. For such purpose, let the matter stand adjourned till May 2, 2023. 2nd May, next
Second.
Tuesday, because 1st May will be that combined list. 2nd May.
Great for me.
Item number 9, Trilok Infracon India Private
Lordship,
Limited.
I appear for the respondent in this
I appear
matter.
for petitioner, my
There
lord.
was already an
There's already an order of
order for filing affidavits, Lordship. I'm just praying for an extension of time to file my
Lord,
affidavit.
I oppose this application, this prayer, because, my lord, the last order is dated 23rd March 2023, my lord. There's no dispute with respect to the arbitration agreement. It's entered into, signed between the parties, acted upon.
Why do you want to
Now-
use an opposition? On what
Lordship,
point?
Lordship, because we had stated that we are challenging the maintainability of the application because the agreement that they are relying upon does not exist.
My lord, I can show here and now.
I can give you time till this weekend only.
Lordship-
Till not this
Lordship-
weekend, till Friday.
Lordship, the only difficulty is, Lordship, the client is based in Guwahati. So I'm just praying for 2
No
weeks time,
difficulty,
Lordship.
ma'am, no. On 23rd March, you were given time by the
1 month, my lord.
Lordship, there was some difficulty with the respondent's
How
family.
long are you
Lordship.
seeking?
Lordship, only 2 weeks. Within 2 weeks, I shall
Only,
file.
only.
My
Lordship,
lord,
2 weeks.
2 weeks I
time.
won't grant. No. In any event, you're
Lordship-
asking for 2 weeks, he's opposing, I'll give 1 week.
very
1
well.
week maximum.
Lordship.
My lord, on the previous day, we were supposed to file a supplementary.
It will be a composite affidavit in opposition then. File it now.
Lordship-
Yes.
Yes, my lord.
Lordship, but
Lord,
there was no
Then I'll
order
give
for
them 2
any
weeks.
supplementary.
Then I'll give them
There
2
was
weeks.
no.
Lord,
File that, they'll get a chance to get 2
May I
weeks.
kindly indicate, my lord, this is only with respect to the service of the letters of section 21, which they
Even
have.
then, even then. I'll direct a composite affidavit in opposition so that the entire matter is done. 2 weeks for opposition, 3 days for reply, if you want.
1 week for opposition, three days for reply.
1.5.
Lordship, kindly.
On the learned counsel for the respondent, at the outset, seeks 2 weeks further time for filing affidavit in opposition. Such prayer is opposed by the petitioner on the ground that the last order directing affidavits was passed as long back as on March 23, 2023. Since the respondent contends that the respondent company is based in Guwahati, and it may be logistically difficult to obtain the settled affidavit in opposition in the meantime, the time for filing affidavit in opposition is extended till May 11, 2023, full stop. Leave is granted to the petitioner to file supplementary affidavit, which is filed today and kept on record. Full stop. It is
Copy.
made clear that the affidavit in opposition shall be a composite one covering the pleadings made in the main application under Section 11 of the Arbitration and Conciliation Act 1996, as well as the supplementary affidavit. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The matter shall be listed on May 19, 2023 for hearing.
Grateful.
Lordship, let them serve the copy of
Should not be part of the order.
Lordship, obliged.
Thank you.
Item number 10,
Yes.
Nilabjo Sikdar versus Tata Housing Development.
Petitioner,
Covering for the petitioner,
what is the difficulty?
the pleadings are complete. Lordship keeps it next week for arguments. Lordship, I have many leaders above me, and the judgments are also required to.
Mr. Ghosh has made time to come and you are taking time.
He's always ready in every matter, but
There is a
But in
problem.
some other court, in some other court.
No.
Yes, what?
Don't record my.
You're going to
consent.
oppose?
What? No, I never
I'll
opposed
record
that.
that. Why not? Convenient.
What? I have not said anything.
Why shouldn't you oppose?
No.
Is there a collusion?
Don't
Very.
record my
On the
consent.
prayer of learned counsel for the petitioner, the matter is adjourned till when? Give me a
Lordship,
date.
next week,
Keeps it on Friday, Miller. It will take time. So it will be easier for me to come. If it's on
Friday week?
Miller, if
Very,
he doesn't.
very. Adjourned till next Friday is a holiday. Friday week is a holiday. So I'll keep it on 4th. Adjourned till May 4, 2023.
Thursday.
Lordship, the affidavit reply be kept on record.
Then
Your
Miller,
opposition
one
have
more
filed already?
indulgence. One day indulgence I stake. Make the.
Character line add করে দিন affidavit in reply file today be kept on record.
Don't
Yes,
keep
what
it
else?
on 4th, keep it then the next Monday morning. Miller, 4th is the commercial division. I get stuck there, Miller. That is the only problem I face, Miller, on Tuesday and Thursday.
Give me a common date. Why don't you give a common? Have a talk between yourselves. Give me right now a common date. I'll put it on the
Eight.
8th.
Monday, 8th.
Let him check his diary because I'm dependent on your diaries basically. Yes.
Sorry, Lordship.
Which
Very well,
date
fourth,
is
Miller, fourth.
vacant?
No, I know.
8th.
Lordship 11th, Lordship. Let it be.
Very well. Very. তাহলে প্রথম লাইনটা একটু চেঞ্জ করবেন on the prayer of learned counsel for the petitioner না on the prayer of learned counsel for the parties the matter is adjourned till May 11, 2023.
Grateful.
I'm sorry, my lord.
No, it's all right.
Pass over vendors. Item number 4,
Yes. None appears even in the second call. Let the matter stand adjourned on the day. পরের দিন এই যেগুলো সেকেন্ড কলে অ্যাডজেন্ট হচ্ছে একটু আমাকে অর্ডারটা দেখিয়ে দেবে অ্যাডজেন্ট ফর দ্য ডে
item number 5,
yes 5 same order yes থার্ড কল করি নাকি থার্ড ফোর্থ ফিফথ কল যদি আসে কেউ anyway so original side matters are over thank you yes now I'll call on the appellate side matters মাঝখানে কথা বললে অসুবিধা হয় না মাঝখানে কথা বললে অসুবিধা হয় না দেখুন অসুবিধা হলে আপনি চলে আসবেন কোনো ডাউট থাকলে জিজ্ঞেস করবেন আজকে 25 মিনিট তবে স্টার্ট রাইট ওহো আচ্ছা থাক তুমি এটাই চেষ্টা করছো তখন থেকে এটাই করার চেষ্টা করছো এই ডলারটা কি আচ্ছা 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 Yes.
Appellate side for judgment, item 1.
Sorry, dismissed on contest. WPS such and such is dismissed on contest without any orders to cost. Are there server copies?
Grateful, my lord.
It will be on the server by today so that you can take whatever steps you can. Yes.
To be mentioned. Item number 2 for correction.
Yes, Mr. Shen, with what correction? Tell me.
There is a small 3 correction. If your lordship come to para 9, page 3,
Para 9, yes.
page 3, my lord, second line.
Oh, this is the marked copy so that you have marked.
It should be 15 years.
It should be
15 years. 15.
5 will be 15.
Lordship, because
So this is
affidavit
an extra copy you have handed over.
yes,
Okay,
lordship.
what is this? Very.
And my lord,
Yes.
thereafter, my lord, para 20. My lord, para
20,
20,
yes.
my lord, third line, it should be 20 lakh.
Achha.
It is 20. And another one is 27, my lord, paragraph 27.
Yes.
My lord,
5 will be 15.
the 5 will be 15. This 3, lordship.
Your other side is you're there. Wait.
I had a talk with him.
Good. It is rightly pointed out by learned counsel for the petitioner, comma, which is not opposed by the WBSCDCL, that in the order dated April 25, 2023, comma, 3 errors had crept in, colon, next, niche, Roman 1, in paragraph number 9 of the same, comma, in the second line, comma, the expression within double inverted 5 double inverted clause would be replaced with the term within double inverted 15. দুটোই words এ হবে মাধববাবু। আচ্ছা, number 2, Roman 2, in paragraph number 20 of the same judgment, comma, in the third line, the figure within double inverted rupees 20,000 shall be replaced with rupees 20 lakh. And Roman 3, in paragraph number 27, comma, the third line, again, the word within double inverted 5 will be replaced with the word double inverted 15. Full stop. Let such order be deemed to stand corrected accordingly, and this order be treated to be a part of the order dated April 25, 2023. Thank you. Yes,
Item
Mr. State,
3.
what correction?
Item 3 for correction.
Item number 3, my lord, it is for correction of the order, my lord. The date, my lord, I may be excused, my lord, date has been mistakenly written as 29th March 2022, my lord. It will be 29 March 2023.
As usual, Anindita. It is rightly pointed out by learned counsel for the parties that the date of the order dated March 29, 2023 has erroneously been recorded as 29th March 2022, full stop. Let such error on the margin of the said order be deemed to stand corrected, full stop. This order be treated to be a part of the order dated March 29, 2023, comma, which was erroneously printed as March 29, 2022.
Most grateful, my lord.
Thanks.
Motion item 4.
What is the matter?
Yesterday,
Ghosh was appearing.
That matter, but
All the matters are that matters. But which matter? Just remind me. Just give me.
replace the meter from one place to another place.
Lord,
Oh,
yes,
oh.
Lord.
So what happened? Why was it adjourned on the last day? Mr. Ghosh was to take some instruction. Mr. Ghosh is there in junior form. Yes.
Lordship, we have communicated on WhatsApp. The lady could not come to our chamber yesterday. So one more.
Please use the microphone. Lady will come.
The lady didn't come out to a chamber yesterday. All the respondents are ladies. Grant us one more day.
So what is the relevance of there being ladies?
Actually, we could not insist them for coming down to the
When should I keep it?
Monday, Lordship.
1 week?
One day, Friday.
1 day. Friday? On the prayer
No,
of
I'm seeking for Friday. If it's adjourned for Friday, Lordship keeps it on Monday, it will be.
Why? Let the ladies come today, this evening. You be there with Mr. Ghosh. I'll keep it this Friday. An adjournment is sought by the respondents. Full stop, let the matter stand over till April 28, 2023, which is Friday. You tell Mr. Ghosh, you could not convince me further. Yes.
Item 5.
Five.
My lord,
Yes.
that matter, my lord, Jana.
That matter, yes.
Lokmal,
Another that matter.
All start, my lord, this petitioner.
Yes.
No, my lord, they could not establish the nexus.
That is Mr. Taroknath Haldar, yes. What was your stand, Mr. Haldar?
My lord, I purchased the suit property from
Mike, Mr. Take it from Mr. Naik, forcefully. Yes.
My lord, suit property, entire property is, my lord, 16 decimals of land.
Right, right.
My lord, out of the suit property belong to, my lord, some Janas. My lord, I purchased the suit property, my lord, out of 16 decimals, 10 decimals of land. My lord, out of 10 decimals, now I transfer the 7 decimals of land to the writ petitioner.
So you are supporting him.
My lord.
Right.
And my lord, I am not concerned with this matter because I am, my lord, the suit property, my lord, was I purchased, my lord,
Naturally, you will
bare land. I purchased bare land. I also transferred bare
already
land.
because all of you will benefit from the default. You have to support him.
No, my lord, I am no way connected to them. I purchased.
And I am
independently
That is a
7
very easy
decimals.
excuse, Mr.
Well, that is a demarcated.
I am
kindly
Court
cease
people
my
cannot establish the nexus and you get scored.
I am all along residing in Kolkata,
no.
my lord.
But the only thing is, in the remaining 3 decimals out, they are still in possession. So, my lord, WB ACDCL is
Can
not
recover from-
remedialist. They can recover from them. 3
Yes,
decimals.
Mr. Naik, what do you say?
My lord, I am extremely grateful because at least one day accommodation has been given yesterday, though order has
Yesterday,
been
that was given yesterday, not today.
not today. And Milord, here the point is, Milord, I'll not, Milord, repeat anything, but I will add, Milord, 3 points. Number 1, Milord, the petitioner has purchased, Milord, the land.
Right?
Because the deed says, kindly, Milord, sees, the land, Milord, valued at rupees 65 lakhs.
Hmm.
That is, Milord, at page, Milord, 39. That's a requisition they have made. Milord, kindly turn it over. Milord, 40. The land valuation, they are saying land 1 and 2. This part, Milord, 65 lakhs. The deed they have shown that they are purchasing the land. And if you lordship kindly sees, Milord, the documents yesterday filed, a huge building of 2nd floor. Building is existing over there and they have purchased, Milord, the land and the building. But this deed is for 65 lakhs, only for the land, not building. Now, Milord, on my instruction, my request, my client has, Milord, forwarded 2 requisition, one for the land and another for the land and building. Lordship, here they have not, Milord, disclosed this land and building valuation. What is the government valuation? They have not disclosed, though they have purchased.
What is your submission? So what is the land and building valuation?
Milord, it is about 97 lakhs. The building is.
They purchase only the land.
They are saying the deed has been given for the land. But the statements have been made, Milord, they want connection for the building. So building which is standing on the land, Milord, that valued at rupees 30 lakhs more. That is not shown in the deed.
But even then, suppose the predecessor in interest of one of the vendors had left the default. Now they have purchased from one of them. So what is the nexus with him?
Not nexus. Milord, I am not on nexus. I'm not.
If there is no nexus, Mr. Naik, you
I'm not
cannot-
another point. Another point is also there. Milord, if they are
That is
benefited.
different. You don't have any locus standi to raise that point even.
No, they are
Distribution-
benefited. If I can show, Milord, we are entitled to recover the amount from the purchaser. If you can show 2 things, either nexus or, Milord, he is benefited by the sale, by the purchase. He is benefited by the purchase, Lordship kindly sees this.
Benefited. Acha.
They are benefited because,
Acha, give me the clause number 13 point.
Milord, 13.9.
55 regulation.
No, 46. Lordship, before that, kindly have a look to this. They could have said it because they are, Milord, asking connection to the building. They purchased the building on the Milord land, but they have not disclosed it. And this is the second requisition where valuation goes up to, Milord, 97 lakhs. And they are thereby, Milord, they are not paying any revenue to the government. No registration fee.
Mr. Naik, there is something else.
Lordship.
They are benefiting from this non-disclosure to the registering authority. Maybe they are not disclosing that they are purchasing the building. They're suppressing that. and they claim a less registry charge. But that is for the registering authority to say. But this benefited from non-payment of the aforesaid outstanding dues by the. How can these people, the purchasers, benefit from non-payment by previous defaulter one generation back?
I am telling Lordship, because that is being flowed away. That's why given Milord the outstanding tree we have given. Milord, that is flowing the legal years, they're enjoying, and Milord 3% they have now Milord sold it to my learned friends.
The defaulter is now deceased.
Yes. This is
deceased.
Yes.
His heirs, they sold to him.
If your Lordship kindly have.
And he is saying not only heirs, as heirs, they purchased and sold.
And that's why, Milord, we have given the tree. The tree says, that is, yesterday I have document. Yes.
Yes, in the
Originally, Milord, Purno Chandra Mal from the documents we have gathered, maybe, Milord, subject to correction, and Milord, it's not sacrosanct. Within Milord 4 or 5 days, Milord, we could not gather anything more out of it. And now, Milord, the legal heirs, Deepak Kumar Mal, and his legal heirs were Milord Konika, Monica, and Devojyoti Mal. They have sold it to
Monica
Milord.
Moinak, not Monica.
Yes, and they have given it to Milord these purchases. Now, Milord, all these are the beneficiary we are showing as it is flowing. Now, Milord, they were enjoying land as well as the building. Now he has said that I am purchasing the land, give me connection to the building. And from the requisition we have obtained, we find that the building and land that goes up to 97 lakhs. Milord, they're not only Milord defrauding or not paying revenue to the government. At the same time, Milord, there might be other creditors also, as like us. Bank, maybe that, we do not know. But for that, for not disclosing that, he is enjoying the benefit. Lordship, for a moment, kindly see Milord 46, 13.9. This is very relevant, Milord, not only in excess, other point is also there.
Benefit from the outstanding dues.
Yes, because they're purchasing in less price. That's the benefit he is enjoying. Lordship, can you see Milord 13.6?
All right, I get your point.
Yes, for getting new connection for supply of electricity.
Sir, Naik, affidavits are directed in this matter?
No.
I'll record your submission. I'll direct you a short affidavit to be filed.
Lordship.
Very short. That benefit point is very interesting.
That is the second part. But all the time we are.
How soon can you file? I want this on record.
Yes. And Lordship, one line, can I place it? Only one day. My Lord, I will please.
So how soon can you file? Annex that. You will take half a minute to annex that. 10 minutes probably to write the affidavit in operation.
Not prompt as my Lord is certifying, but 1 week.
1 week for affidavit. You are ready with the documents.
I'm ready with the document.
Take the weekend, file it on Monday, Mr. Naik. They'll file reply within 2 days and then I'll take up.
Tuesday, Lordship.
This is electricity.
And
matters,
one
so we
thing,
cannot.
what I respectfully submit, my Lord, this benefiting point has to be, my Lord. I request.
So definitely.
They're not only this matter.
Other matters also.
Other matters also that has not been, my Lord, placed by us.
No, you did place in one matter there. They did not benefit directly for regarding this payment.
But this,
but this is a very interesting point.
commodity matter. There it is. Bank's liability.
You have to bring these on record because I cannot proceed on these documents unless you bring those on record and they cannot reply.
Lordship.
They have to give a reply.
Lordship. I will.
I'll give you 1 week, Mr. Naik. I'll give them 1 week, Mr. Das. And how long should I give you? 1 week, another 1 week or 3 days?
3 days.
Learned counsel for the WBSEDCL seeks to place reliance on certain documents to indicate that the petitioner purchased the property, including the land as well as the building, comma, in the garb of purchase of only the land, comma, thereby paying paying less amount of consideration than the market value of the entire property. First up, it is sought to be contended further that in terms of clause 13.9 of regulation 46 of the West Bengal Electricity Regulatory Commission, comma, if it is established that the applicant has had a nexus with the previous consumer, including the purchaser, etc., and or has had benefited from non-payment of the aforesaid outstanding dues by the previous consumer to the licensee, comma, the new applicant may be compelled by the licensee to deposit the previous outstanding dues before getting the new connection. First up, it is submitted that even if it cannot be said to a great extent that there was nexus, comma, for argument's sake, comma. Definitely the petitioner benefited from the less payment of consideration and was a beneficiary of the outstanding dues, comma, due to which the purchase price decreased according to the WBACDCL. Full stop. Next para, since the WBACDCL seeks to place reliance on certain documents, including those pertaining to valuation of the property, comma, the respondents are directed to file their affidavit in opposition within May 4, 2023. Full stop. Reply, if any, shall be filed by May 10, 2023. The matter shall be listed on May 11, 2020.
Grateful.
Mr. Haldar, I have not directed you to file in your opposition. Obviously, you will not be filing. But if you want, you can support even file. I don't think it is necessary.
Because I am not concerned in any way because
The only thing is you are not concerned actually.
residing in Calcutta. I purchased bare land. I also transferred bare land. On the deed
If you have so many things to say, use an affidavit.
Common it is, Lordship.
Grateful.
Item 6.
Yes, Mr. Rai.
Lord, I appear for the license.
But the unfortunate consumer or the fortunate license?
Fortunate license.
Fortunate license. Where is Mr. Prashanto Bandhavade repeatedly absent? No. Once you prayed for adjournment. So 50-50 now. I'll. Yes, you are for the petitioner.
Item number.
Why are you hiding behind her?
No, my lord. I'm just asking. My lord, I have.
You have reached court. Yes. What do you have to say? Move the matter. You are the junior of Mr. Bandhavade. Mr. Banerjee.
Poti Mukherjee is leading me.
Achha. Prashanto Bandhavade appeared for the petition. He has given a change. This is not Sarika Bibi versus West Bengal.
Yes, my.
Anyway,
Yes,
whoever
yes,
you. So what is your case?
Advocate on record, Saidul Haq Mullah and Mr. Poti Mukherjee is leading.
Anyway, what is your matter? Tell me.
The petitioner is the husband of the.
Please use the microphone. Just come closer to the microphone. What is your name?
Arijit Ghosh, my lord.
Mr. Ghosh, yes.
The petitioner is the husband of the deceased, my lord, who has unfortunately died due to the electrification, my lord, in 2000.
Oh, achha. Compensation.
Compensation, my lord. Petitioner has made his representation before the authority, my lord.
Which authority? Let us see.
Yes.
Yes, Mr. Rai, what do you have to say?
Lord, we'll have to use an affidavit, Lord, if the writ petition is entertained. Lord.
How soon compensation? Not very soon, but do it quickly.
Because
whatever, Lord,
this lady is suffering
earning member.
naturally.
And due to electrification.
2 weeks, I'll give.
Can it be 3 weeks?
Whatever Mr. Mukherjee says, 2 weeks. The petitioner has sought compensation due to alleged electrocution of her husband, comma, since deceased, comma, allegedly due to the negligence of the CSC Limited. Full stop. Next para, learned counsel for the CSC Limited seeks to controvert such submissions and use an affidavit in opposition. Full stop. Accordingly, the respondents are directed to file their affidavit in opposition by, I'll give you 3 more days and a weekend. By May 15, 2023, full stop. Reply, if any, shall be filed by 3 days. Can you do it? By May 18, 2023, the matter shall be listed on May 19, 2023. That will be the last day before the summer vacation.
I'm deep.
Yes.
Great.
7.
Your Lordship, in this matter, I'm led by Mr. Kishore Datta, learned senior counsel. He has requested me to pray for an adjournment on his behalf, Your Lordship. Unfortunately, he will not be available for today and tomorrow. I was asked to pray with Your Lordship if the matter can be kept on Tuesday, if it at all.
On the, you're for the petitioner?
Yes, for the I am for the petitioner.
On the prayer of the petitioner, the matter is adjourned till May 2, 2023.
As Your Lordship directs.
Excused.
Grateful. Grateful.
Yes. I'm grateful.
Thank you.
Item 8.
Yes.
My lord,
Yes, sir.
the petitioner is a foundation and minority educational institute run by the foundation. Now, the foundation has a land at Barasat, and they are running one engineering college over there since last 10 years. And now the respondent, West Bengal State Electricity Transmission Company Limited, decided to draw a high tension cable line over the premises of that minority educational institute, which is nothing but abrogation of the fundamental right of a minority educational institute under Article 30.
What is minority to do with that? I mean, this is public utility. I mean, you're being a minority community. How can that strengthen your right on this? Because this is not an atrocity against minorities.
No, my lord.
Unless you say that, I mean.
My lord, I have annexed the.
Be going too far, probably.
Okay, my lord. The National Commission for Minority Educational Institutes is declaring the institute which is run and administered by the minority communities, either on the base of community or language or religion, whatever.
Doubt on that. What is the immunity you get from these electricity atrocities?
No, if the electricity high tension cable is passing through over the land of this minority educational institute, it has to be closed, because the regulatory bodies required land for minority education, any institution free from all encumbrances. So if and that institute has already applied for a university.
Show me that regulation or law that it requires it from free from encumbrances. Just show me that. What right is infringed, you have to show that. So therefore, please just rely on that.
My lord, please.
What is this? Tell them.
This is West Bengal government's policy and guideline for setting up private universities.
Why didn't you annex it to the writ petition?
Actually, I get it afterward, my lord. I have annexed the Supreme Court judgment where a 5-bench judge headed by the then Chief Justice S.P. Bhattacharya categorically mentioned that if the existing laws is not enough sufficient to mandatory acquire the land of minorities, if the government wish to acquire land and property of minority education institute, it has to be confirmed that the right given to them under Article 30 is not abrogated and infringed.
Was that in connection with a public utility project?
Yes.
What was the project in that Supreme Court judgment?
It was the post office.
Show me that, judge. You have annexed that?
Yes, my lord. Yes.
Show me the relevant paragraph.
It is in page number 79, my lord.
Yes. 79, right. 79 is the relevant portion.
Yes, the last paragraph of my lord. Can I read, my lord?
Please.
We cannot accept the submission of the learned Attorney General that the provision of a statute that provides for the acquisition of property in general, as for example, the Land Acquisition Act, are adequate for the compulsory acquisition of the property of minority educational institute, because what is payable thereunder is compensation, or that the provision of clause 1A of Article 30 should be read into such statute. Clause 1A clearly states that after the date of its introduction, there must be a law that specifically relates to the compulsory acquisition of the property of minority educational institute, and that the law must take provision that ensure that the amounts that are fixed or determined thereunder for the acquisition are such as do not restrict or abrogate the right guaranteed under Article 30. Necessarily, such law must require the taking into account of factors that do not come into play in the determination of amounts payable in relation to the acquisition of the properties of other, and are therefore not set out in the general acquisition statute. We think, however, that is appropriate that Parliament and the state legislature should have time up to 31st May 2002 to make such a law if they so choose, and that pending and uncompleted acquisition of the properties of minority educational institute should lapse only if at the end of such time the statute under which the acquisition have been commenced have not been duly amended. On the other hand, if they are duly amended, the amounts payable for such acquisition shall be determined thereunder. So, my lord, my humble submission is that after this judgment, neither the existing Land Acquisition Act amended or any new legislation has been introduced.
Can we please just once come to the facts of this case? Just the bare facts of this case. Your Supreme Court
This case.
Supreme Court case.
Yes, my lord, in this case, there was one post office in one minority educational institute. So it was 150 years back. Then it was on rental basis.
Right.
So after some time, the institute has requested for enhance of the rent. So without responding to the enhancement request, the government has decided to acquire the building in which the post office is situated. So then they have challenged it.
Very relevant,
my lord.
And you please cite the other thing you were citing.
Yes, my lord. This is, my lord.
You got extra copies of that because
I can give you that, my lord.
No, you will have to give a copy to them also so that they can come.
No, it's a government notification, my lord.
Cite it, yes.
This is West Bengal government policy and guideline for setting up private universities. Here, mandatory requirement is no applicant shall be permitted to establish a private university unless such applicant is in possession of continuous landed property having absolute title on it and free from all encumbrances, not less than 7 acres. That we have. But if it goes through the campus, they have also provided us the map. I have annexed that map in page number my lord, 83. If the cable goes through the area, the entire campus would be bifurcated into two places.
So two questions arise basically. One is that within the contemplation of that Supreme Court judgment, whether this is acquisition.
Yes.
One, because they will obviously argue this is not acquisition, but this is user of that property.
Yes, they have mentioned it.
Will be one limb of it.
Yes.
And the other limb will be whether it's an encumbrance within the contemplation of this guideline.
Yes.
These are the two main questions. There.
Yes,
very interesting. Yes. But you have to cite copy. I don't have any copy right now.
No, I am giving you that. 6.C, my lord.
This is a question of law, Mr. Paja. Come prepared on this.
Yes, my lord. But one thing, my lord, already observed that this judgment, Supreme Court, probably is not applicable here.
No, that obviously your argument will be it is not acquisition.
Absolutely.
No, that is the only question to be decided. Two questions to be decided, which I just formulated. If there are any other questions, suggest to me, Mr.
Yes,
Paja.
yes, my lord. According to my instructions, my lord, we have diverted this line
from over their property
to shape the residential building and other things of the locality. We diverted the line, and out of 135 meters, first of all, Miller, we have more or less completed the project. Few, out of 70, only 3 towers are to be erected.
I'll formulate the questions, file an affidavit, disclose those things. Because this has to be in those housings versus this minority education, where minority education has Article 30 in its favor, apparently. He's right on that.
Probably I have no quarrel with this because I am not you'll also already observe. I am not acquiring.
I have not observed that. I am saying that is an arguable question, which is for the purpose of this judgment, whether acquisition, this can come within acquisition for the purpose of this judgment. The connotation has to be looked into. Because acquisition may have various shades. Land acquisition is outright acquisition.
Yes.
In this case, it was outright acquisition.
Yes.
But whether this can be extended to your user of the property, which virtually tantamounts to render one of the portions of the property is unusable. So if it's a school, then that becomes very relevant. Whatever it is, it becomes relevant. But Mr. Paja, that has to be looked into. That is a very arguable point. And the other is whether this government circular is binding first. whether it is, if it is binding, whether this amounts to encumbrance. This will be your arguments basically, and he will controvert. So these are the questions which are to be decided. But since you are taking the point that it has been diverted and to save other residential structures, and there
Yes.
are other points also, those are not merely on law, those are on facts. We have to look into those. So how soon can you file an opposition? This is one of the few matters where I am inclined to grant opposition, because this will be an interest, clash of interest between the residents of people and this minority institution, which is claiming. So it will be, I mean, apparently an unequal clash, but we have to look into it.
Another thing, Milord, I am disclosing my defense here and now, so that my learned friend can.
So
Milord,
then
we-
don't file an affidavit. Are you agreed on that? That he cannot be agreed.
My lord, one thing, my lord. When the agency wish to draw a line, they have some plan. According to the plan, they have to draw it.
Yes.
My senior has already accepted that they have diverted. Why they need to divert? Because the other people cultivating land and everything, they have objected. So they can negotiate with them because they are not minority, they are not under any fundamental right. They don't have any fundamental right which I have. So it should be better for them to negotiate with them without compressing on us.
Yes,
It will be a
Here I
nightmare.
am.
It will be a nightmare for the court when it comes up for hearing, because it's education versus cultivation.
Yes.
The worst possible conflict. I mean, anyway, we have to decide it. So
File later, we
have to-
requested them.
how soon can you file an opposition?
I'm saying, Milord, but just now my learned
You want to,
friend- I'm
Mr.
getting-
Paja, then argue on the matter,
Yes,
right?
but no, just now my learned friend said.
No, we are not on this torture sort of thing. Either you use an opposition or argue right now. I'm ready to hear the matter. No difficulty, because this is a very interesting question, has to be decided.
And my lord, our university inspection is on 29th, my lord.
No, we are not on facts. Mr. Paja, if you argue, please argue right now. You're ready on the matter.
ঠিক আছে
File it within a week then.
হবে তো? Yes.
Two very interesting questions have been raised by learned counsel for the petitioner in the matter. First, whether the intended drawal of high tension electricity line over the property of the petitioner, which runs a minority educational institution, tantamounts to acquisition within the contemplation of the judgment of the Society of St. Joseph's College versus Union of India and others, rendered by the Supreme Court of India, annexed at page 76 of the present application, consequentially rendering the intended drawal bad in law as opposed to Article 30 of the Constitution of India. So the second question which has been raised is as to whether the parties are governed by the West Bengal government / policy and guidelines for setting up private universities dated January 31, 2013, published in the Kolkata Gazette of February 1, 2013, which envisages that such minority institutions have to run on encumbrance-free land, semicolon. If so, whether the drawal of electricity line, of high tension electricity line, tantamounts to single inverter with the encroachment within the contemplation of the said guidelines. Next para, since learned counsel for the WBACDCL controverts the arguments on several grounds, including certain factual ones, such as allegedly the line was deviated from previous plan to leave alone certain residential areas, which would otherwise be affected, the respondents are directed to file affidavits in opposition within. Today we are on 27th.
My junior is requesting your lordship that 2 weeks if I get.
Very well. Within May 12, 2022, 2023, reply if any shall be filed. What will be the time for filing reply? 3 days or 7 days?
My lord, as the management is in Hyderabad, so I want a longer time, my lord.
How much? Tell me.
My lord, 7 days, my lord.
Very good. Reply, if any, shall be filed by May 19, 2023. Full stop. The matter shall be listed for hearing on the reopening date after the upcoming summer vacation of this. Because that is the last day.
Obliged, my lord.
My lord, may I get that copy, my lord?
Yes,
Yes,
yes, definitely. That's why I take that number so that I can share.
Thank you very much.
What is your name, please? Full name?
Utpal Das.
Mr. Utpal Das.
Yes, sir.
Very. Thank you. Call him.
Lordship.
Item 9.
Yes. Next.
Lordship, I am for the petition.
Right.
Lordship.
What is the matter?
The matter is, Lordship, I've made a representation before the SEDCL authority regarding, Lordship.
Have you served properly on them? Just check up your.
Lordship, I have served them, but that track report I have not.
When did you
recovered
send? When did you send? See from the postal receipt?
25th, Lordship.
25th. So we are too early for that. Let us wait till next week then. Since service has not yet been completed properly on the respondents, awaiting such service, the matter is adjourned till May 4, 2023. Next Thursday, I'll be taking up the matter.
Lordship, I'm grateful.
You file your affidavit on that.
Lordship, I'm grateful.
Item 10.
Yes, Mr. Patnaik, you are for the Regulatory Commission.
No, my lord, on behalf of the planet advocate, on of the petitioner, my lord, I am praying for not to.
That's very well. An adjournment is sought by the petitioner. Let the matter stand adjourned for the day.
Grateful to us.
Specially fixed matter, item 11.
May I try to answer your lordship's query, my lord?
Sorry. Yes, Mr. Shen. I remember my promise made yesterday. Yes. So I'll be open to that argument.
My lord, your lordship takes the writ petition. Paragraph 2 first.
Mr. Pachal, please take your seat. Yes. I'm sorry. Paragraph.
I'll briefly indicate, my lord, what should be my endeavor. My lord, in terms of the special bench judgment, the test for an occupier to be entitled to apply for electric connection must be a person, even a trespasser, but with the rider that the trespasser has to fulfill the criteria of being in settled possession.
Absolutely.
And my lord, there are certain tests which have been laid down when a person can be of settled possession. Mere fact of production of one document may be statutory in nature without any further particulars as to the date when I have come into possession, through whom I have come into possession, where I am in possession, what is the period of time through which I am in possession. These are some.
Mr. Shen, I was only against your contention that you have to, for appointment of a special officer to ascertain visually who is in occupation.
But why I said
but
this?
Otherwise you may have a good case on the ground that you can show that they have not made out a prima facie case of settled person. That you can argue always.
That is what I was trying to.
No, that you can.
Yes, that is what I'm.
But I am against just appointing a special officer who will go there and see one of the parties standing there with a flag or whatever, and he'll come back and say he's in possession. This exercise I don't prefer.
I made this suggestion only because of certain documents which they have annexed. I cannot demonstrate visibly that document is false or forged or whatever it is.
Arguably, they have got that's prima facie.
That's
arguably
what I'm
prima
saying.
facie possession.
No, that
but
is
not
what I'm
settled
saying.
person.
Yes.
Very good.
That is not that I wanted to say. That document by itself does not fulfill the character of a person being in settled possession. And therefore, but since it is a question of grant of an electricity meter, I was trying to say that court can come into the aid of this kind of a person if the court is otherwise satisfied through other means available to the court to find out, no, he is in possession. That is for satisfaction of court, not for us. Because my main contention will be from his averments and his documents, he is not in settled possession. He cannot be in settled possession. But what is going minuscule percent against me is 2-3 documents, which are statutory. I am discarding completely the
By
private
any
documents.
stretch of imagination, do you think personally that, I mean, as an advocate, not personally,
Yes.
that a visual inspection, which will take over a period of say 15 minutes, half an hour, 1 hour, can that disclose who is in settled position? Can it be?
I mean
Can
to
it
say,
be?
because of the
More so because it's settled position, not physical position, visually only at that point. Settled position is something
can
a
my
bit more.
learned friend, what actually I am a creature of instructions. What I have been made to
No,
say.
Mr. Sen, why not? Absolutely, you have a right.
No, what I have been made to believe is this.
Yes.
It is a vacant land.
Then it's all the more difficult.
Yes, what I say, vacant land filled with products, staff, and a structure where only my person can be seen. I could have understood my learned friend is also showing even a small structure situated in one corner, which he has, I give him the doubt, which he has made over a period of time. That photograph is also not there. That look here, the court is being shown, because this is a slightly different case from the type of cases which your lordship has.
What are you running there, Mr. Shen?
My
According to you?
Transport, and I have all the photographs.
Transport.
Yes.
I mean, it's a
loading, unloading.
Unloading is there. It's a go down sort of, you say, or the vehicles are there.
It's no, there is no shed, but it's butted and bounded. And there is a main gate. That is what, my lord, I want to show from his document also. My lord, kindly see just 2 paragraphs.
Show me from his documents, Mr.
Paragraph 2.
Yes.
He says his business is also concerning with transport, which is being run from a go down.
So then
kindly see.
That will be seen there as per both of you.
Exactly. But I wanted.
But you see, your goods will be there.
I can show. I don't know whether my learned friend has shown photographs or not, but I can show photographs, and his documents are only from 21. Earliest document which I find here is 2021. I am in possession with from Port Trust, adverse to Port Trust, whatever. The civil court has protected my possession vis-a-vis my interest with Port Trust. So I go a much longer way down. Not only that, my lord, if your lordship once sees
your remedy lies elsewhere, Mr. Shen. Not in this.
Once kindly sees the trade license. I do not know how far
whatever yes.
This
Which
will be
page?
helpful to me, but I must show this.
Which
Page
Mr.
12.
Shen? Page 12. Yes.
Page 12.
Right.
He has paid fee under section 102 for certificate of enlistment, under section 87 capital A for fee for specific service, and thereafter kindly see serial number 3, keeping, storing, in warehouse, go down, transport. There is no fee. This is not a license for transport. That is number 1. And number 3, kindly come to the bottom of this certificate, NB Roman 3. This licensee is liable to submit a copy of NOC from Pollution Control Board, Fire Department within 3 months from the date of issue of this license, failing which this license shall be treated as cancelled. And the respective trader shall be deemed to have carried out business without proper authority. So, my lord, 2 things.
Yes.
Vis-a-vis his statement in paragraph 2, he does not have a lawful license for carrying on transport business in respect of this address.
Right.
And number 2, he should not be allowed to rely upon this document as a prima facie proof of his possession, because it is conditional, which condition he does not say has been fulfilled, and therefore this is automatic cancellation.
What about the telephone bill? Similar.
Telephone bill, my instruction, I cannot back it up. It is not there in that property. If I ring this number, it will be at his residence. This is, my lord, entirely, my lord, on instruction, nothing on record. But Now, my lord, vis-a-vis this document, we lordship vis-a-vis. Then another thing, my lord, which my learned friend ought to have shown also in his several business documents which he has annexed, particularly in the affidavit in reply, there is a GST code which he has mentioned. Now, my learned friend should therefore disclose before your lordship, for the purpose of registration of GST, what is the certificate, what is the address, business address which he has shown. Now, why is this relevant? Because kindly, my lord, may I, your lordship knows the judgment, my lord, but still for my satisfaction, my lord, kindly take note of this. It is here.
With the reference session?
Yes. 2000, AIR 2011, Calcutta 64.
Oh, sorry. Going on. Yes.
Yes, but this is now followed everywhere.
Yes, because this is the three judgment.
Kindly see here, it was a case of complete squatter and encroacher in this matter. And your lordship will see paragraph just after point number 2, before entering into those questions, following material facts may be taken into consideration. I'll read from here, then it will be.
Point number 2, yes.
Just after point number 2.
Yes. Before entering. Yes, got it.
The writ petitioners involved in all these applications are admittedly encroachers of government revenue land situated in such and such. Kindly note, they encroached upon the land after the month of April 1993 and are in possession by making construction of their residential accommodation. So this is a primacy fact that they were in possession by way of some construction being there. That is conspicuously absent in the pleading here. You are running a godown. Court can see the godown. Where is that godown? Number 2. Now let us come to the factual aspect of the issue, my lord. Kindly see thereafter. Actually, I have read it in my
your tab.
Yes, the only advantage is sometimes, my lord, if I am late, the print may not come from the advocate on record.
That's an absolute advantage.
So, my lord, I mark it here.
So you can read out from there. You
Yes,
can.
I just say, my lord, kindly see a little thereafter.
Are there bold letters? Is that SCC online or AIR on? AIR on?
SCC online.
SCC online.
I think
No,
your
tab.
It will tally SCC online.
So should tally then.
But page number.
Page number need not. The bold letter. There
Yes, kindly come to.
If the trespasser is a bold letter portion.
Section 43 is quoted.
Yes, got
just above that, the question falls for consideration whether an encroacher of land owned by administration is entitled to get connection of electricity.
Got it, yes.
So that is the question, encroacher. Now, 43 is quoted. I am not reading 43. 43 only mentions on an application by owner or occupier of any premises. Then, my lord, your lordship will kindly just come after 43. Broad question before us is whether a person who is an encroacher upon the land belonging to another without any right or permission conferred with an owner can be treated to pay an occupier within the meaning of section 43. In the Electricity Act, there is no definition of the word occupier.
Right.
Next paragraph, these rules are also important.
Yes.
Works of Licensee Rules 2006, framed under the aforesaid Act, came into force in the year 2006. And according to the definition of occupier as provided in Rule 2B, unless the context otherwise requires.
There it is lawful.
Yes.
So it is interpreted.
Yes. Then kindly see Rule 3.1 of the rule authorizes the licensee under the Act to carry out works, lay down or place an electric supply or line or other in through or against any building over or under any land whereon over or under which any electric supply has already not been laid down or placed with the prior consent of owner or occupier of any building or land. Similarly, for the above purpose, the licensee may fix any support of overhead line or any stay or strut required for the purpose of securing its position any support of any overhead line. According to Rule 3, if any objection is raised by the owner or occupier, as the case may be, to the proposed works to be carried out by the under the rules by the licensee, such dispute should be resolved by district magistrate or commissioner of police or any other officer authorized by state government in this behalf as indicated in Rule 3. So,
Mr. Shen,
there
there is a
mechanism.
subtle difference between the two. I'm telling you, subject to what you say. I mean, these works of licensee rules have to be read in conjunction with the Telegraph Act, which is also applicable to these electricity matters, sections 10 and 16. So even if you take the works of licenses rules, these operate when some licensee wants to do some work on some property.
Yes.
There an element of compensation is there, damage is there. Ultimately, it has to be fixed to whom the compensation is to be paid. The liability has to be fixed vis-a-vis the payee. So in that case, lawful occupier becomes relevant. Lawful occupier, this definition in works of licenses rules is relevant. But when we take into consideration only section 43, where because that will be it will be premature to consider whether works of licensee rules will apply, because those will come in when the lines are laid. Before that, whether a person has a right.
Yes.
Now, for that one need not be lawful.
Yes.
But when the line is taken over somebody's property, that person has to be lawful. So the contexts are different.
No, but here it has thereafter been interpreted that what is lawful occupier in 43? Ultimately, that your lordship will kindly come slightly a little later.
Yes, it is.
Kindly come towards this part. Kindly come with the, it is starting.
That is
with,
lawful occupier in the rules. That has been interpreted.
No, but issue was encroacher and squatter.
True.
Kindly see, kindly come thereafter, my lord, according to the law in India. Paragraph starting with. There is a bold quotation.
Yes.
If the trespasser is in settled possession.
Yes, yes, yes.
Just above that.
Yes, according to the law in India.
My lord, before that paragraph also kindly see, if we accept the reasoning of the learned referring judge, that only an occupier with perfect legal title to occupy can apply for electric connection. In that event, in the absence of consent of the owner, no person even in lawful possession shall be able to get connection of electricity unless he has got a decree from civil court declaring his occupation lawful. In case of dispute with tenant, a landlord can, by taking advantage of such interpretation, easily raise false disputes as regards the status of the tenant and ask the licensee not to grant connection so long the status of tenant is not declared as lawful. According to law in India, a person in settled possession of immovable property cannot be dispossessed otherwise than when such a person is settled, although commencement of such possession was unlawful, can restrain even the lawful owner from disturbing in settled possession otherwise than in due process of law. Then when 2004 Supreme Court has been quoted. Kindly see, these are the quotation from AIA 2004 Supreme Court. I am not taking your lordship there because this is repeated thereafter. Kindly see next paragraph in Munshi Ram case. Next paragraph.
Yes.
It was held that no one, including true owner, has a right to dispose of trespasser by use of force if the trespasser is in settled possession of land. In such a case, unless he is evicted in due course, he is entitled to defend his possession. But merely stray or even intermittent acts of trespass do not give such a right against the true owner. Possession which a trespasser is entitled to defend right to owner must be settled possession extending over a sufficient long period of time and acquiesced to by the true owner. A casual act of possession would not have the effect of interrupting the possession of the rightful owner. Then, my lord, there is another case in Puran Singh, court clarified what is settled possession. My lord, there are 4 ingredients. Settled possession must be effective, undisturbed, to the knowledge of the owner, without any attempt at concealment by the trespasser. Then, my lord, your lordship will see these are the 4 factors and tests which have been given in bold. Trespasser must be in actual physical possession of the property over a sufficiently long period of time. Possession must be to the knowledge, either express or implied, of the owner, or without any attempt at concealment by the trespasser, and which contains an element of animus possidendi. Nature of possession would, however, matter to be decided on facts. Process of dispossession of the true owner by the trespasser must be complete and final and must be acquiesced by the true owner. Then kindly come to the next paragraph. When the rules of 2006 were introduced, the legislature had in their mind the aforesaid concept of settled possession, which was capable of being defended against any threat of dispossession, even at the instance of the owner, except by due process of law laid down by the Supreme Court, and consequently introduced the definition of the word occupier as lawful occupier without further defining the word lawful therein, because it is relating back to 43. Therefore, in the absence of any definition of the word lawful in rules of we should apply the principle of settled possession laid down by the Supreme Court to the phrase lawful occupier. So this judgment is ultimately deciding lawful occupier in 43. Rules have been referred to only to say that even the rules do not define what is lawful occupier. Is free to then kindly see appear in the rules for implementation of the object of Electricity Act to construe the same as a person in settled possession whose possession can be defended against the threat of dispossession otherwise than by due process of law, even by the lawful. So the test is, if the rightful true owner had gone to court, could my learned friend's client defend his so-called possession against the true owner? So that is one of the test of, he does not even say that through whom he has come into possession. I say, I may not have a valid legal right, but I have come through port trust. And I have defended my possession vis-a-vis the true owner, port trust. He must tell your lordship that I just can't drop from the sky. I have to enter somehow.
Mr. Shen, I mean, with utmost respect, this is a three-judge judgment and I'm fully bound by it. Why me? Another three-judge bench will also be bound.
Yes.
But one aspect of the matter disturbs me. I'm telling you, one perspective. Now, in this particular matter, probably arguments were made in that fashion. Now, Section 43 was interpreted in the light of 2006 rules because there were a discrepancy in language regarding occupier. 43 says occupier and the rules say, 2006 rules say lawful. It is mentioned as lawful occupier. Occupier means lawful occupier. Now, but this mixing up for the purpose of interpretation of Section 43, I have my little doubts on those. Because I tell you this, because of the last thing I told you. Because the logic should be 43 comes first.
Then the question of laying.
Then the question of laying, because two are on different fields. The lawful occupier, the 2006 occupier or lawful occupier, that is for the purpose of deciding who is entitled to compensation or on whose land it is being laid. He is a different person from the person who is asking for electricity. 43 does not have any such fetter. Now, lawful fetter is there in 2006. When I lay, suppose I lay a line over your property to Mr. Pachal's property, he is getting the connection. Section 43 is his right.
Yes.
And 2006 rules are your right to get compensation or to get a notice. Now, two are on different footings. How can we mix up the two and compare the two for the purpose of interpreting Section 43? That is my little difference with utmost respect to the different division judgments. Because that remains, I'll have to mention it. I had an urge of saying it somewhere, but I can only speak through my judgment. So thank you for providing me the opportunity.
But here your lordship will see that.
No, but what is your answer to that?
43 is saying application by owner or occupier.
Only occupier. No lawful occupier is anywhere there in the statute.
Then, my lord, if we come to now in the context of
Mr. Shen, think over it. You'll get 10 minutes for that. I'll come back in 10 minutes.
But if we read, my lord, section 43. is duty to supply on request. But my submission will be 43 cannot be completely divorced from the rules. It is the first stage. 43 contains the duty and the obligation. Once the duty and obligation is absolute, that crystallizes into the right of the licensee. This is not worded in the form of a independent statutory right. It proceeds on the basis of an obligation.
Their duty.
Their duty.
That includes the laying of the lines also.
Yes.
Get your point. Very good. I also thought of that in the.
Because there are other provisos also.
Yes.
First body of the section is my duty, licensee's duty on an application by owner of to give supply of electricity. Within 1 month of receipt. Then there are certain provisos.
Yes.
Subject to those, my duty and obligation is absolute.
Very good.
And when I process his application, along with that, I must know that I just can't put a meter there. That will be meaningless.
True.
I will have to give a meter, take a decision for giving him a meter, and also simultaneously take the decision that this meter I can install here only upon lines coming from my mains, coming through this area, connecting to this meter. Because your lordship's order is always make an inspection and then decide where it is to be. That is full discretion of the licensee.
True.
So therefore, 43, when I decide that I will have to give him a meter, when I have to perform my duty, I will have to take into account all other factors, including the laying of lines, where it should be laid, and ultimately how it is to be connected to that meter, so that I will comply with my duty.
But here, according to the CSC, probably they are in prima facie position. That is a CSC stand in your case.
CSC has not taken
In submissions, they are probably
their stand is, as far as available from the writ petition, there is an objection by the private respondent. They want to lay their hands off.
Very good.
This is the situation where they have come to court. And my lord, this full bench judgment, that is why the court has gone into the question of the rule.
So if you see it as a duty, that has this rider also, you have to lay the line.
You have to lay the
for
line.
which 2006 rules becomes relevant.
Rules have to come.
Very, very acceptable.
And
yes,
that is
yes,
why,
very.
my lord, the meaning of the word occupier as appearing in the rules has not been fully accepted.
No, the rest has been followed.
Full
Rest
bench does not say that because it defines occupier as a lawful occupier, therefore lawful occupier should apply to 43.
No.
Full bench says that the referring judge has said that, but that interpretation cannot be accepted. Lawful is to be read down to mean settled possession, and settled possession is this.
So somewhere in between, sort of.
Somewhere.
Very good. Get your point.
These are the tests. So, my lord, if I now apply the tests of this judgment, then, my lord, your lordship will have to examine their averment.
Yes.
Where do they, on what averment do they say they come within the purview of a settled occupier? They have not said, I have come through whom. They could have said, they have come through Port Trust, they have come through another subtenant, whatever it is. Just, it's like I'm just dropping from the sky, I have a go down. When did your business start?
No antecedent, no narrative behind.
That is what. And I have shown, my lord, the prima facie statutory document which was going against me. That is a conditional license. You have not said that you have performed that condition. And the statutory authority who has granted you the license says that is automatically cancelled. So therefore, my lord, that document has to be ignored for the purpose of assessing his possession.
Very good.
That is number one, my lord. And the other document, and he says transport. Document does not show that he has got a license for transport. And my lord, this BSNL document, I would I cannot make any comment, but then he should have shown that the telephone is there. But at least in this type of cases, at least, some photos are shown that here I have a thatched house also, thatched roof. There's something of that sort, my lord. And one thing, my lord, the police report is there. Whatever weight your lordship will place on that.
Police report goes in your favor or his favor?
My favor, and it says civil dispute.
No, civil dispute is there. Definitely there.
Yes,
It
my lord,
is there.
civil dispute.
No doubt on that.
Position. There is a commissioner's report of 2010.
You have
Page-
annexed that to your opposition.
Yes, page 19 of the affidavit in opposition, which clearly says that I found a plaintiff, that is my client, so suit properties identified. There are properties, RT shed rooms, RT structures, trailers, lorries, trucks, 100 workers. Then, my lord, 144 এ police report টা কোথায় আছে দেখো তো?
Mr. Sen, please give me the pages of the relevant.
Yes, my lord. First is, my lord, regarding my
Commissioner report. Page
commissioner,
19.
commissioner report is page 19.
Yes.
This is title suit number 90 of 2010 filed by my client against Sport Trust,
yes.
where I am enjoying an order of status quo
Right.
with regard to my possession. That order has not been interfered with in the misappeal. Appeal has been dismissed.
Yes.
Yes. My lord, page 61 of the opposition is a police report in respect of a 144 proceeding, which has been referred to by my learned friend in the petition also.
Yes, he has.
Page 61 says, during inquiry, second paragraph, holding number 35/1, Jagat Banerjee Ghat Road, is a land go down under name and style of RKB Poly Industries Private Limited, having his registered office at such and such, owned by the petitioner's late father Kamlesh Tiwari. After demise of Kamlesh Tiwari, petitioner carried on business. At present, OP members trying to take possession forcefully of the go down from the petitioner and obstructing. That is not concerned. What I am on is, my lord, the police report ought to have mentioned one place, there is another place of business of another party. Somewhere, because the land as such it is vacant with a go down and butted and bounded.
So petitioner's position is not established by any cogent.
Any. And my lord, my suggestion yesterday was only in view of this. If the court wants to, because it is a question of electricity, wants to exercise discretion in favor of the petitioner, since there is not sufficient materials, I would have prayed, my stand would have been kindly dismiss the writ petition because of disputed question of fact. That is that, my lord, I should say it is an alternative submission by me in view of certain documents being disclosed, but the court must be prima facie of its opinion that yes, there is something to say that the plaintiff with the petition is in settled possession.
Right.
Therefore, the court on its own can find out the situation. I am not, kindly do not visualize that I am saying that a special officer has to be appointed.
No, I understand.
That is my
The court can satisfy itself
Yes,
always.
sir.
Very.
My prayer is disputed question. He is not in settled possession. His pleading is otherwise. His documents are otherwise. Therefore, kindly dismiss the writ. And since your lordship may not go into such disputed issues at all, therefore your lordships cannot exercise discretion. But if your lordship is in favor of a prospective consumer, then to satisfy yourself, that is my submission. Court is not powerless to make an inquiry. I think these are my.
Thank you. Very well argued.
Obliged.
Yes, Mr. Pachal, what is your? Oh, yes, what is your stand? So much paraphernalia is not required, Mr. Mukherjee. What is your stand on this? CSC Limited.
First of all, my lord, the writ petitioner applied before us for new connection. The your lordship knows, my lord, with the application, they have to submit some documents. What they have submitted, one is, my lord, BSNL bill, and another one is, my lord, the trade license, allegedly trade license, my lord, issued by the Howrah Municipal Corporation. Now, my lord, on the basis of the same, my lord, but this is the offer letter which has been issued to them. Now, my lord, if your lordship consider once the offer letter at the
Give copies to all, Mr. Mukherjee.
but no, this copy I am giving to.
Any particular sentence of this you want to rely on?
My lord, kindly see the right hand side top.
Yes.
But just give me 1 second, my lord. But if you lordship see the nature of supply, low voltage overhead. Then, my lord, type of supply, new load, new service. Nature of job, new service. Now, my lord, if your lordship see, my lord, what we have stated with reference to your application received through Annexure A for obtaining supply at the above and our subsequent inspection at site, we are pleased to provide you our offer for supply. Our service connection charges for carrying on out the work is mentioned in the table above.
What is relevant about it, Mr. Mukherjee?
But only thing is that, my lord, your lordship,
offer letter on the basis of trade license and telephone.
my lord,
Yes.
after going through the opposition, my lord, if your lordship, although, my lord, I can't say anything about this suit, but in the suit, my lord, the plaintiff, that is Mr. Sen's client, filed an application for local inspection. If your lordship consider once page 19.
That indicates that
Yes. They are in. If your lordship kindly once.
No, but whether that can bind them, that is another question.
Yes, because they are not the party to the suit, my lord. Therefore, my lord, that dispute, my lord, regarding the possession title, my lord, I cannot say anything. And whether in read court, my lord, your lordship disputed question, your lordship will interfere. That is your lordship discussion.
So what is your stand means? What is your
But they have applied. They have applied.
You as licensee, what to give?
They have applied.
As
with
Mr. Sen said, you have to be neutral on this. Either way, I mean.
Because they have produced 2 documents.
Maybe a bit biased towards them because they're applying for a commercial connection.
Not that,
Maybe.
not all.
Theoretically, maybe, but may not be in practical reality. So, Mr. Mukherjee, I'll hear Mr. Pachalkar.
But they can also satisfy them whether the person who has applied is actually there.
They will satisfy themselves.
I will do it. It will
That
be
is one of the reasons for non-visual inspection. But then I'd have to relegate that to the CSC also.
That is my overhead connection. This will be my temporary overhead connection. This will be. If we at all be.
So how does it improve the situation?
Nothing. Nothing.
Yes.
My lord,
Mr. Pachal, short reply.
just short reply, my lord. Whatever I have annexed in the read petition, you have already gone through, my lord. My learned friend has referred to paragraph 2. Perhaps, my lord, the paragraph 4 has lost sight.
What is your answer to the prior facie evidence that they have shown regarding their exclusive possession? One is commissioner report, although you were not party there, but there is something on record to show they are in possession.
From the commercial report itself, we also will find. Well, that's why, my lord, I will have to make some submission in this, my lord.
Yes, yes, absolutely.
My lord, you also kindly take trouble to look to my reply, my lord. There I have annexed certain documents in reply to their opposition, my lord. There you also will find the documents concerning with trade license and telephone connection, not other documents I will refer to, my lord. My lord, all the business challans in course of business, my lord, those challans are issued in the name of the petitioner, my lord. You'll also
Followed in
will-
the name of the private respondent. Oh, Rohit Karwo is you.
Yes, myself, my lord. You also will find from page, my lord, this is very relevant, my lord. All the pages are relating to Rohit Cargo.
Yes,
Plus
it's 11 onwards.
in course. Now, the bank document, when the bank will not issue, open the bank account without the proper document in favor of the petitioner. You will also will find paragraph page 35 onwards. The entire bank statements have annexed. You also will get the address. Unless not I satisfy the bank as regards my relevant documents concerning with the property, not no accounts will be open, not the entire statements of facts will find. Now, what I am carrying the business? I am carrying the business of transport. Now, you also kindly take trouble to look to their supplementary affidavit.
Lord, I ought to have shown it, but I was just not shown. Lord, I made a submission regarding the GST. But I have, they have searched and got the GST number which they have shown. I am giving a copy to my learned friend, it's showing a different address. in the GST
But that is
portal.
not a part of the record, Mr. Sen. I cannot look into that.
But the
this
GST number is there in their invoice, which they are relying upon.
The GST authority will take
Not
care
at
of
this
this.
stage after the hearing is over, Mr. I won't look.
Address is completely different.
Maybe.
But I'll give a copy to my learned
No,
friend,
no,
let
not
him
that.
take instruction. on
Let me
this.
hear, Mr. Pacha.
Why I am referring to that commissioner report, not that.
Tell me what you are going to say.
My lord, Your Lordship.
Yes.
Your Lordship, kindly take trouble to look to their supplementary affidavit. Not my specific case is they used to carry out business of PET, my lord, the plastic bottles. That will appear from the documents they have annexed on page 25 onwards. Although these are all my lord, self-made computer documents, Your Lordship will simply astonished the page 25 document dated 15th February 2013. The name RKB Poly Industries. Now, my lord, their affidavit in opposition, Lord. They have stated that Kamlesh Tiwari died in the year 2015. After he died, not the name has been changed from RK to this Poly Industries, RKB Poly Industries. The 2012, 2013 documents have been annexed. These are all manufactured documents showing that they are manufacturing PET bottles. All the documents is also fine.
That's why manufactured.
PET,
Yes,
PET
yes,
bottles.
yes.
Not the poly, this is poly business, not that's why the name is RKB Poly Industries Private.
Right, right. Yes.
And so, my lord, from the commissioner report, as your lordship has already referred to, nothing has been stated as regards the manufacturing of poly business. The garage has been mentioned. Now, your lordship kindly take trouble to look to.
What about a trade license not paying anything regarding
This is consolidated tax.
Achha.
This is consolidated tax, not covering all, not you'll also kindly see in one head, the amount was charged.
This was fees for specific services.
Yes, this is the normally not
That's why all the other heads are zero.
zero. No other charges has been specified. Now, you'll also kindly see they are supplementary affidavit, page 8, page 9. These are the trailer available, the photograph.
Vis-a-vis your matter, the Howrah Municipal Corporation and the CSC Limited are in the same hands. Mukherjee knows.
Howrah Municipal Corporation, we don't.
You used to appear for
2011.
Yeah,
After that, no.
this was issued after that.
It is the current after 22, 23, not the photographs they have annexed in their supplementary affidavit.
Very well. I get your point, Mr.
The trailer available, they are not. These are my trailer. Till it is available. The sand must stacked therein. Also, my
according to you, what will a special officer go there and see? What will be seen there?
Not my vehicle.
Vehicles are there, admitted, both sides agree.
They are not doing any business there.
So then we'll have to go into the question of the registration number of the vehicles. And then you have to impute the motor vehicles also.
I used to carry transport business. I had a number of goods vehicles not lying there. They are a document. They have stated.
By hope of deciding this in court right now.
144 proceedings.
So I'll have to go into the documents, each and every of the each and all of the documents. I'll have to. Anything else?
These are my submissions.
Third, learned counsel for the parties. Full stop. Although the learned senior advocate appearing for the private respondent seeks to place reliance on certain documents, which are not part of the record, on the ground that those documents are germane for the adjudication of the position of the parties, such leave is refused, since the said document has been sought to be relied at an advanced stage of the arguments when the arguments of the private respondents has been concluded and the petitioner has begun his reply. Full stop. Let the matters hence hearing is concluded and the judgment is reserved in the matter. I'll just check up all the documents I'll have to see. So, but Mr. Sen, you have made out a very arguable point that nobody can deny. Very arguable point. Even on the documents annexed.
That GST document, my learned friend can also show your lordship for his case. I need not show, my lord. He has.
Go out of the, but Mr. Shen, we have to
No.
stop somewhere.
In order to
Otherwise,
get
Mr. Mondol
electricity.
will be producing several documents even after the hearing is
No,
over.
no, I will not.
I'm telling, I can assure you, I worked with him.
Okay.
Yes.
If
Application item 12.
My lord, can you short passover, my lord? On the-
Why? You move the matter.
Mr. Susanto Pal is elected on the 19th code, my.
19. You are also for the petitioner. Move the matter.
Just for 15 minutes.
No, start the matter.
For the private respondents.
Yes. And you're for the licensee.
My lord, on last occasion, you have directed the.
Take the microphone. Yes.
I
Please
have
take the
served-
microphone, Mr.
I have served all the respondents.
Absolutely. Yes.
And I filed the affidavit also.
What is your case?
I'm not getting the connection of electricity, my lord, since July 1912 to 2012.
What is the reason, Mr. Mukherjee?
My
I'll
lord,
come to you later.
2012, my lord, pursuant to an application for new loop meter, we went for inspection, we were objected. Then also again, we tried, my lord, we have been objected by
So
the.
consistent
Yes, we are-
objection by the.
What my instruction is, my lord, we are ready and willing, subject to, my lord, we get an opportunity to inspect along with police help and with a direction to, if we found it is feasible, my lord, with a direction to break open padlock.
Yes, what is your
My lord,
objection?
only one more thing, my lord. If my lord may kindly come to your lordship's order, dated 12th of April. My lord, there was a direction to hand over the copy of the connected application, my lord.
What was the connected application?
My lord, we have not yet been handed over with that. And probably that has been filed by the opposite private respondent.
What is that application?
No, I do not have find any application.
And kindly see your lordship's order.
Can, yes, old can such and such. এর সঙ্গে কোনো ক্যান অ্যাপিয়ার করছে অরিত্র বসে আছে কিন্তু চুপচাপ কোনো ক্যান লিস্টে অ্যাপিয়ার করছে এটার সঙ্গে this can is there application for substitution.
We have not been served on the last occasion. I have pointed out this and it has, I may be wrong, but it has been submitted from the bar manner that the
So this is
private.
the application of the writ petitioner.
But it
Substitution
has been, we have not been served. We have only been served with the copy of the writ petition.
Has this application been allowed? Substitution application.
I think so, my. It's allowed, my lord.
Not in the records.
Man.
And allow the substitution application. Have you given a copy of, not given a copy to anybody?
I given the copy of the writ petition, my.
Sir,
That copy,
Application, have you given to the private respondents? They are also not aware of this application.
no, my lord, not given.
that is
One
the-
page application, you could have given a copy. This should be over by 10 minutes, not even 10. What is your objection, by the way?
My lord, I'm appearing for the respondent number 5 to 7. My lord, 5 has died in the meantime. My lord, the petitioner is a private tutor by occupation. My lord, the backdrop of the case is that the respondent number 5 during his lifetime allowed the petitioner to run his coaching center in respect of 2 rooms in the
You
ground
say he's
floor.
not in lawful occupation.
Yes, my lord.
Is he in occupation at all?
Yes, ma'am.
Then
he-
he's entitled.
He is running his coaching center, my lord.
If that is admitted, he has right to get electricity. So let us give a copy of the substitution applications during the course of the day, please. Do you yourself have a copy of the substitution application?
I have to go through, you see.
Keep it on Monday, man. I don't.
No copy of the substitution application, comma, which is appearing along with the writ petition, appears to have been served on the respondents. First of next para, learned counsel for the private respondents further points out that in the meantime, respondent number 5 has expired. First of, the learned advocate for the respondents shall communicate the particulars of the legal heirs of the deceased respondent number 5 to her counterpart appearing for the petitioner by tomorrow. First up, necessary steps shall be taken by the petitioner in the meantime
My lord, 6.
for substitution of the said legal heirs. First up, the matter, the writ petition shall be listed along with the subsisting substitution application. and the further application which may be filed by the petitioner in the meantime, on the next returnable date, the matter shall be listed on May 15, 2023.
Respondent number 6 and 7 are the son and daughter-in-law.
No, you have to give in writing to them. On the basis of that, they'll file a one-page application. I'll take that on record, lock, stock, barrel, everything I'll decide.
My lord, may I file the death certificate of respondent?
No, give whatever you have to give a copy to them.
My lord,
Annex that and file a
My lord has been pleased to keep it on 15th of May.
15th of May.
I'm good.
In between that, they'll do give all copies to them.
My lord, may I pray for one indulgence? My lord, any day accepting 15th, can it be fixed? My lord, I have some difficulty on 15th.
16th? 15th na kore 16th kore do.
I'm good.
Next.
Item 13.
I'm appearing for the writ petitioner, my lord, on last occasion that is on 27th of March 2023, my lord. My lord was pleased to direct me to file opposition. My lord, I could not file it. My lord, I begged for 2 weeks time, my lord.
So much time was given to you.
My lord,
1 month was given.
My lord, due to Ramadan and thereafter the Eid festival, my
I'll give you
client,
3
my
more
lord,
days. 3 more
my
days.
lordship,
Ramadan is long over.
kindly 2 weeks, my lord.
No.
That will,
No. You're trying to delay the matter.
lordship kindly.
No.
1 week, my lord. My lord, it is very
Opposition to
difficult.
what?
Opposition
Our
to the
application, my lord.
opposition to the application for substitution.
No.
That is
Not substitute.
application for addition of party, my lord.
No. Why should we?
My lord,
No.
there are plenty of
Opposition
documents,
to
my lord.
application for addition of party, long back 1 month you have been given.
Lordship,
Ramjan, you could have said then, you knew then it
lordship,
will be coming.
lordship 1 week, my lord.
No.
My lord, I'm in difficulty in my personal difficulty also. Lordship kindly takes it.
This matter, your lordship has already disposed of around the writ petition. The state government, my lord, preferred an appeal. Now, my lord, my learned senior friend client filed an application for recalling of lordship's order because in their absence, order has been passed and they have been virtually affected. Now, my lord, according to them, something has been suppressed before your lordship, my lord. That's why your lordship,
My lord has already protected.
What happened in the appeal?
The appeal, my lord, because my lord, your lordship has already, my lord, grant stay, therefore, my lord.
My lord, both the applicants are already protected by your lordship's order. That interim order of stay of operation.
Lord, I'll not say anything. I leave it to your
2
lord.
weeks time, Your Honor.
Grateful, my lord.
On the prayer of learned counsel for the writ petitioner, the time for filing opposition to the application for addition of party within bracket can 4 of 2023 bracket closed is extended for 2 weeks from date, for a further period of 2 weeks from date.
Grateful.
Full reply, if any, shall be filed within a week thereafter, Mr. Sean. Reply there, if any, shall be filed within a week thereafter. Full stop, the matter shall be listed in the monthly list of June 2023. That will be the reopening date of June.
Grateful.
I'm grateful.
Grateful.
Item 14.
Yes. Yes, Mr. Kaur, what is the matter?
Lord, your lordship had passed an order directing my client to make payment
Yes.
by installments of 15 lakhs quarterly. A total sum of 1 crore.
Yes.
My lord, I have paid the amounts. My lord, as soon as the payments are being made, there is a late payment surcharge added to the bill of 5 lakhs or 6 lakhs, 7 lakhs. My lord, that was not your lordship's order.
Can you please show me my order, Mr.
Yes, my lord. Your lordship's order is at page 11. Lordship will come to the bottom of the page. The bill was raised for the billing cycle October 2019 with the reading date as November 1, 2019. The total amount of dues as per the bill was 1 crore 90, out of which the due for the current period was 7 lakhs 9, and the alleged arrears for the period from September 2014 to April 2019 compared with the comprised of the balance. The petitioner has made payment with regard to the current consumption, but has challenge the alleged arrears of 1,83,00,000. This was the amount directed to be paid. If your lordship comes to page 21, paragraph 40.
Yes.
Hence, writ petition is disposed of by directing the petitioner to pay the entire amount due in lieu of additional electricity charges for the billing circle September 2014 till April 2019 by 4 quarterly installments of rupees 15 lakhs each. The first of each such installment shall be paid. Now, my lord, I had prayed for installments of 15 lakhs to pay the entire amount. This is the first. And second, this does not permit the department to add in the bill late payment surcharge. There are two reasons why. First is your lordship's order that does not direct any payment of late payment surcharge. Second, if your lordship comes to page 30, my lord, the order of the RGRO, paragraph 3.
Paragraph 3.
Well, I don't know whether the page is readable.
In my copy, yes. Probably your copy is worse.
I
Yes, it
can't
is
read.
worse.
That is why I was asking. Well, may I try? The paragraph 3, my lord. The unclaimed bill charge for the period of September 2014 to April 2019 for rupees 1,83,00,000 is found to be in order and appears to be claimed following concerned section of the Act, and calculation has been made on the basis of rate and tariff applicable in respective period allowing rebate thereof. The unclaimed bill is found to be in order and correct, which was also accepted by the petitioner, consumer. The consumer can be provided suitable installments or supplementary bills if applied for, and no late payment surcharge should be imposed for realization of such payment. So this was the order against which the department did not appeal. I came up before your lordship. They have accepted this order. And now, my lord, your lordship will see the bill. There are two bills I have annexed at page 36 and 37. These are dated data. দেখে বলো দেখি আমার আমি পড়তে পারছি না Milord, first is at 36 and second is at page 37.
1st of October 22.
First of, Milord, the 1, 2, 3, 4, 5, 6. Sixth item from the bottom. Late payment surcharge. Has your lordship got it, Milord?
Yes.
7,25,000, 7,25,000 and odd. Now, my lord, your lordship will come to the next bill. Your lordship will find again at the same place. 10 lakhs has been added as late payment surcharge.
9,72,000 and all.
9,70,000.
Yes, yes. Next page also. 10 lakh. It becomes
10
10 lakh
lakhs.
something. Yes.
These are the two items. Immediately the payments are made. They make this payment to adjust it. Milord, these are the two items.
But against that GRO order, you preferred an appeal before the ombudsman.
Ombudsman has approved the order of
the order
RGR.
exactly
Your lordship has directed payments.
Against that, you came up in the writ petition.
Yes,
So entire period litigation was pending.
Yes.
Great.
Milord, they have not
Challenge
preferred any
that
appeal from that
record.
order. So, Milord, my two clarifications or things I want before your lordship. Your lordship directed entire payment, I will make the payment. But entire payment I'll make by installments of 15 lakhs quarterly. Milord, your lordship has given 4 installments and balance by, my lord, possibly there was some. I had prayed for 15 lakhs installment quarterly. Your lordship had given me that. Paragraph 40, my lord. So these are the two clarifications or modifications I am seeking from your lordship. First, they cannot claim late payment surcharge. And that is the order of the RGRO. And secondly, my lord, your lordship had directed payment of by 15 lakhs quarterly. I was praying if your lordship will kindly extend it for the entire period.
No, you had paid total amount is the total
1 crore and odd, out of which I have paid 45 lakhs by 3 installments.
No, you had given to four installments of 15 lakh each.
My lord, I have paid installment for September, December, March.
Right.
3 installments of 15 lakhs each, 45 lakhs.
Have not rounded off the balance.
My lord, your lordship has given me installments up to September.
True. So you will have to round off the balance, the rest of the amount if it remains.
That will
September.
remain. I am praying if your lordship will kindly allow me to pay by 15 lakhs installments. Also.
15 lakh?
Installments of quarterly installments of 15 lakhs. That was your lordship's order.
No. Mr. Kaur.
Lordship.
I don't get you properly. I'm sorry. 15 lakh each, 4 installments were given to you.
And balance.
And the balance. What is the balance?
The balance is 1 crore and odd.
Balance is 1 crore and odd?
Yes. My lord, I don't know. I had said that I'll pay by installments of 15 lakhs. My lord, if your lordship sees the order of RGRO also, there is no bar to the installments being given. These are the two.
When will the installments end then? If it is.
It will be ending another 8 installments, my lord.
Another 8 installments.
My lord, I will pay, my lord. If it is within my means, I will certainly pay. I have carried out the order of court.
So if there are installments, then definitely if you can pay before that, you can. But you want 8 more installments after September 30th, 2023.
Lordship.
Very. Let me hear.
But I will not, my lord.
LPSC GRO did not impose. How can you?
My lord, on this part, my lord, superis is not to claim, my lord, LPSC and further installments which is not, my lord, covered by your lordship's order. Shall I take instruction on this? Because
no, need not take instruction.
Monetary matter.
Another law you cannot. Another law you cannot, and I'll give him the installments, 8 installments.
I'm not. Let me.
What are you, the petitioner?
Let me come back, lordship.
Lordship.
What are you? What is the petitioner doing?
Now I am paying installments.
No, you're a business.
Business, huge business, my lord,
huge business.
Yes, Provopoli pipes. My lord, it's a monthly.
My lord, when it comes to.
They will pay up the amount, Mr. Your argument without this, unless you have any apprehension that the WBSC DCL will be wound up in the meantime before 80 installments are paid.
No,
that can be an apprehension.
I
Otherwise,
am not standing in the way in any way.
They can pay. They will be paying up. It's public money. You will recover it.
But I will just want to have instructions on this. I am not opposing.
No, I am not waiting for your instructions, Mr. Naik. Definitely. What are your arguments on law? LPS is a legal argument totally. Installments is a discretion. I don't want any concession on your part. Definitely not.
Matter is disposed of. And my lord, now they have come up with this application. For
clarification, probably there is some doubt. I'll hear Mr. Kaur on that issue, whether by way of a modification. But this is a composite application sort of. I mean, it's captioned as an application for modification and or clarification.
Lordship.
So virtually a component of extension of time is also there. An enlargement of time.
Enlargement.
So I'll read that to you. These are technical.
If so, please, my lord, I am not on these technical issues. Because the company will get the money, certainly.
They made that prayer in the prayer portion. The prayer is that.
My lord, only thing is this, my lord, this representation she would have made before this making this application. He could have approached our company also because it's a order of. Because my lord's order is there, and he on
clarify my order on there.
And not what I am on is so far as the LPSC is concerned, my lord. That part, my lord, I want to argue because
argued right now. it's a totally legal point, Mr. Naik. Every matter cannot be adjourned for
My lord,
instruction.
my lord, LPSC is a matter of under the legal provision it is. Now, my lord,
That
RGRO,
was waived by the RGR. You did not challenge.
RGRO, my lord, that part I want to, my lord, I want
No, no,
to reconcile.
I'll decide it.
My lord, because he has challenged that order in, my lord, ombudsman's order.
He had challenged, not
He
you.
has challenged.
So obviously he did not challenge a particular portion.
I am not sure because that is not before me.
No, no.
Right now,
It is not on the records, Mr. Naik.
It is not because in the application also he has not annexed that also. I could have taken support of it. Let it on Monday.
When was this served on you?
It has been served.
Then why didn't you take
Let it on
instructions?
Monday, Lordship.
Every matter cannot be adjourned, Mr. Naik, like this. Why?
No, one part may be
It's a
allowed.
very specific claim of Mr. Kors. What is your answer to it?
My lord, only thing is this, my lord allowed our claim. And now he has paid. Until unless payment is made, we
No,
cannot
no, this
also-
cannot be adjourned.
We cannot also, my lord, ask for any, we cannot make any calculation on that. Now, my lord, 15 lakhs installments was granted for, my lord, rest of the, my lord, maybe.
Could not make any calculation over so long a time. A copy was given.
No, until unless payment is made, my lord, how long it is delayed? That period, my lord, we cannot assess.
No, he's on 15 lakh. Without the LPSC, obviously, he's.
No, yes. That's the on
That why can't that
that's
be
the principal
calculated?
amount, Lord.
Why can't that be? Yes, principal amount.
Let him pay. We might decide, my lord, that
Decided right.
rest of the installments. But so far as LPS is concerned,
No, no, LPSC also will decide. Learned,
that should be
the learned
should be
senior
given
advocate
go by.
appearing for the petitioner contends that it was not clear from the order of this court dated November 29, 2022, passed in WPA 20630 of 2022, as to whether the late payment surcharge was also to be paid by the petitioner along with the principal dues. Full stop. Secondly, comma, it is argued that since installments of rupees 15 lakh each was sought by the petitioner, comma, but the balance amount as per the order under modification comes to around rupees 1,83,07,977 oblique dash, comma, let the said amount, comma, instead of being rounded off with the last installment, comma, be also paid in further installments of rupees 15 lakh. Full stop. Next para. Mr. Court, please take your seat. Mr. Naik, please take your seat. Learned counsel for the WBACDCL controverts such contentions and seeks some time to take instructions from his client on the calculations concerned. Moreover, comma, on the aspect of late payment surcharge, comma, it is argued that the WBACDCL has a statutory right to claim such amount, comma, which was not curtailed by the order passed by this court. For sub next para, it has been rightly contended by the learned senior advocate appearing for the petitioner that the entire genesis of the genesis of the entire case was the order of the grievance redressal officer, comma, which specifically stipulated that no LPSC charges would be levied by the WBACDCL. For sub next para, although the petitioner has challenged the same before the ombudsman, and subsequently the order of affirmance of the ombudsman before this court in the writ petition, comma, there was no challenge evident from the records on the part of the WBACDCL or any cross objection, comma, to the finding of the grievance redressal officer regarding non-payment of LPSC charges. Full stop. In the absence of such challenge, comma, it does not lie in the mouth of the WBACDCL to claim that the petitioner was entitled to pay LPSC charges as well. For sub next para, the order of the RGRO ultimately merged with the order of this court, comma, passed in the writ petition, comma, none of which contains any direction to the petitioner to pay the late payment surcharge. Full stop. Next para. Moreover, comma, since litigation was pending during the entire pendency of the matters before the grievance redressal officer, comma, the ombudsman and the writ court respectively, comma, it cannot be said that the licensee is entitled to claim late payment surcharge, comma, since the delay could not be attributed entirely to the petitioner, but also has to be tagged with the long pendency of the matter before different forums. For next para, hence, comma, there is no scope of further charging LPSC from the petitioner on the part of the WBSCTCL. For next para, insofar as the further installments sought by the petitioner is concerned, comma, it is seen that the present application also contains an element of enlargement of time. Full stop. Relief A claimed in Can 1 of 2022. No, relief A to nahi eta. Sorry, relief A jeta bolam, relief A in Can 2 of 2023 includes a prayer for the petitioner to pay the balance amount, comma, totaling to rupees 1 lakh, comma, 83,07 1 crore, I'm sorry, 1 crore 1, comma, 83,07, comma, 977 by further installments of rupees 15 lakh. For next para, the objection taken by the WBACTCL to the effect that the said prayer extends beyond the scope of clarification or modification of the order cannot be accepted, comma, since merely in view of the additional component of enlargement of time, comma, which has been made as a composite prayer in the application for clarification stroke modification itself, comma, the relief itself should not be held to be barred due to such absolutely technical objection. For next para, considering the balance of convenience and inconvenience of the parties and the fact that the petitioner has made the payment of the initial installments, comma, thereby showing its bona fide, comma, it would not be improper to grant further installments for payment of the balance amount to the petitioner, comma, more so since the primary objective of the WBACTCL, comma, a public utility service, comma, ought to be to recover such public money from its consumers. First, a mere disconnection would not serve any purpose to such end. Full stop. Hence, comma, Can 2 of 2023 is allowed, comma, thereby observing that there was no rider in the judgment and order dated November 29, 2022 regarding payment of any further charge of any further late payment surcharge within bracket LPSC by the petitioner. Full stop. Hence, comma, there is no scope for the WBACTCL to levy such additional charge on the amount due. Full stop. Moreover, comma, the time for filing, time for deposit of the principal dues by the petitioner is further extended. Full stop. The petitioner shall be entitled now, that the petitioner shall be entitled for, shall now deposit the balance amount of rupees 1,83,07,977
After deduction of 3 installments.
Yes, I'll say that. After deduction of the first 3 installments, comma, within further further installments, comma, each a monthly installment of rupees 15 lakh.
Quarterly installment.
I'm sorry, quarterly installment of rupees 15 lakh each. Full stop. Next para.
Until the entire payment is made.
Full stop. Such payment shall be continued till the entire balance amount is paid. Full stop. However, comma, it is clarified that the said payments would be over and above the current electricity charges payable by the
Yes, sir.
petitioner
Yes,
for each billing cycle. Full stop. Next para. In default of payment of any of the installments as indicated above, comma, however, comma, the WBSEDCL will be entitled to take appropriate steps for disconnection of the petitioner's supply on such ground. Full stop. In the event the payments are duly cleared as per the above direction, comma, the WBSEDCL shall not create any disturbance in the enjoyment of the electricity connection by the petitioner. Full stop. No address to cause certain.
Grateful to you, Lordship.
One indulgence may I appeal?
Yes, yes,
My lord, in default of payment of any installment, we are entitled to disconnect without any notice. This can be added.
Well,
Lords.
They're running a business there. That's why I said no. I did not say that.
Highly appreciable the dues claim, the dues.
Without any notice, this practice
Crore.
is very bad, Mr. Naik.
2
Why
crore.
without notice?
Because
Give a notice, I'll disconnect. You have not complied. They'll
They'll
get a chance to come before this court. At
And
least.
also, my lord, they are getting enough,
Not without
because
notice.
they are not paying any interest over the dues. This is public money after all. Late payment such as.
It's
only for
better than
that
getting
purpose.
nothing, Mr. Naik. If you disconnect now, you'll get nothing of this due.
That's
It will become bad debt entirely.
that.
As opposed to that, without interest, principal dues, 1 crore is sufficient.
And all will have to suffer. Lordship.
I'm grateful to you, Lordship.
Without that rider, Mr. Naik. I agree, but without the last rider, you say. Let's call on the next one.
Grateful. Lords.
Old matter, item 15.
Yes.
15, my lord, I appear for the petitioner, my lord. My lord,
And
there is a.
My lord, I appear for the CSC Limited. My lord, these are old matters. We need to
When
look
should I
at the
keep it? Tell
papers.
me.
My lord, we'll need at least 2 weeks to locate the papers. We don't.
My lord,
have-
only thing, my lord, later, I have talked with Mr. Mukherjee, my lord. He was saying that he didn't have the paper, my lord. My lord, wow, one thing, my lord, let it be recorded, let there be a direction on my, I shall start that, including their opposition, my lord.
Learned Counsel for the CSC Limited seeks an adjournment of at least 2 weeks for the purpose of enabling them to contest the matter effectively, comma, since the matter is quite old and the papers are not being traced out in the office of the CSC Limited. Full stop. Learned Counsel for the petitioner is gracious enough to offer a service of copy of all the relevant documents, comma, including the pleadings of the CSC Limited to the learned advocate on record for the CSC Limited. Full stop. Accordingly, the petitioner shall serve copies of all relevant pleadings and documents in connection with the writ petition, which is in custody of the petitioner, to the learned advocate on record for the CSC Limited by tomorrow.
By tomorrow.
Full stop. The matter shall next be listed for hearing on May 15, 2023. 15.
Grateful, my lord.
15.
My lord, under the same heading or my lord, with some
Headings may change.
differences? My lord?
What's in a heading? What's in a name, Miss Seva?
No, so that matter may be taken up, my lord, going to put matter.
Which matter is not being taken up, Miss? So few matters. Yes, call it.
Item 16.
16, yes. এগুলো কি প্রথমবার এসছে? হ্যাঁ? None appears for the parties, adjourned for the day না করে adjourned for the week. এগুলো monthly লিস্টে দিয়ে দিস।
Item 17.
My lord, same prayer, my lord. No records.
None appears for the petitioner, although the respondents are represented through counsel. Let the matter stand adjourned till May 15, 2023.
Grateful, my lord.
This matter is after 15
18.
years. 2008 matter.
18.
8.
No, this is item 18.
Yeah,
Yes.
yes, sorry, I tell you.
Yes, yes.
I am the writ petitioner in this matter, rather we are the writ
Still
petitioner.
interested, Mr. Upadhyay? You have changed sides in the
Yes,
meantime.
there is a stay of operation of the order of the ombudsman.
I can vacate that, no difficulty. If you want
It
a
is there.
So
I
these
want
matters are pending unnecessarily. Mr.
unnecessary pending.
Probably your problem has been resolved in the meantime. I don't.
No.
Not resolved.
No.
Then move the matter.
The order
Move
is
the matter.
staring on my face.
Then
Well,
move the matter.
only point I have taken, your lordship already decided this issue. That's why I was talking to my other friend and I requested him, my junior.
Just
probably
give me a
for-
copy if I,
Yes.
they were saying, my lord, there is an order by your lordship. I said, just give me a copy so that if
So that you can find out the appellate order.
No, the point is very short. Your lordship already.
point টা তাহলে
held-
বলা কি দরকার?
কেন
আপনি তো
বললে
ultimately
একই তো হবে, টাকা তো একই হবে।
When should I keep it? When can you find the judgment to hand over to Mr. Dhar?
Yes, I had a talk. He was there.
When can you do that? Hand over.
Next week,
He is there in many matters. You are there in many matters. Are you supposed to remember those?
no,
Mr.
I said next week. I had a talk with him. That's why
next week.
next Thursday.
ঠিক আছে?
On the prayer of the parties, the matter is adjourned till May 4, 2023.
Lordship.
4th May. ডেকে দাও এত দেরি করো না ডেকে দাও অর্ধেক ম্যাটারে লোক থাকবে না
19,
None appears for the parties, adjourned for the week.
20,
20 Miller, I am the respondent in this matter. Miller, Mr. Roy is also appearing. But
Should I keep it next week?
as you lordship please.
None appears for the petitioner. The respondents are represented through counsel. Let the matter stand adjourned for the week. Mr. Rai, if you can please just communicate to whoever is appearing for.
21,
হয়ে যাবে তাহলে। None appears for the parties, adjourned for the week. শেষ যদি করে দিই তাহলে শুভ্র বাড়ি। Yes.
22,
Same.
'23,
In 23, lordship, I appear for
Next
WBC.
week.
As your lordship desire.
None appears for the petitioner. WBSCDCL is represented through counsel. Let the matter stand adjourned for the week.
Grateful, lordship.
Try to inform the other side.
Lordship, I will try.
Ask your junior to.
It will be difficult because the 2008 matter, I am also trying to, no notice has been received, but our record says so. I am trying.
আচ্ছা, আচ্ছা, আচ্ছা। You can check the files of the court
Lordship,
to
that
see, ascertain the advocate on record for the petition.
I'll do that, right. Grateful, lordship.
Not you, ask your junior to do it.
No, if they will be.
Yes.
24,
My lord, I appear for the petitioners. My lord, I'll need 2 weeks to trace the records. Old
Very
matter, my lord.
On the prayer of learned counsel for the petitioner, the matter is adjourned till May 11, 2023.
Grateful, my lord.
25,
None appears for the parties, adjourned for the week.
26,
26, my lord.
Petitioner,
Yes, my lord. I am appearing on behalf of the petitioner, my lord.
you are for the, this is for the respondent.
Respondent,
Give a notice, sorry, give a notice and come back on Monday.
my lord, may I submit one thing, my lord?
These are old
My
matters.
lord, in pursuant to your lordship's direction, my lord, yesterday I have affirmed the affidavit in reply.
Acha.
But my lord, my case is depend only upon one report of the joint inspection. My lord, for that reason, I have filed one application under section 6 of right to
When
information.
should I
Act.
keep it? Tell me, Mr.
My lord, may I pray for,
June.
no, my lord, pray for file supplementary reply, my lord.
When do you want to file it?
My lord, next week, my lord.
File a composite reply. You have not yet filed your reply.
No, but my lord, I
I'll
have
extend the
served.
time. File a composite reply.
Yes, my lord.
You have served a copy.
Yes,
Give another copy. You give another notice
Yes, yes,
saying that I don't want to rely on that. This is the composite.
yes, my lord. Yes.
When
My
do you
lord,
want to do?
Wednesday.
Learned counsel for the petitioner submits that subsequent to the affirmation of the intended reply, comma, certain other documents have come up within the knowledge of the petitioner for which those are required to be annexed to the reply as well. Full stop. Although a copy of the intended reply has already been served on the respondents, comma, the time for filing affidavit in reply is extended till May 3, 2023, when the matter shall next be listed. Full stop. The petitioner shall serve an advance copy of the amended affidavit in reply, comma, which shall be filed on the next returnable date for the first time, in the meantime, on the respondent.
Gratefully.
Thanks. দেখে দাও, দাঁড়িয়ে আছো কেন?
For hearing,
বুঝতে পারছো না তুমি?
item 17, 27.
27, my lord, in this matter, learned advocate Mr. Atish Kumar Biswas is appearing on behalf of the
Not today.
petitioner. Gratefully, lords.
On the prayer of the petitioner, the matter is adjourned for the day.
Grateful.
The matter to
28. Well, I appear for the private respondents.
Lord, I appear for the petitioner.
What is the matter about?
Well, Lord, the matter is regarding the shifting of electric meters of the private respondent.
You are for the private respondent?
Well, I was only praying this. My
When?
advocate record, all of them today, they are in Delhi in. So
When
if
should I
it
keep
is-
it, Mr.?
Can it be in the next week, same day?
Which day suits you? Or you?
Thursday.
Thursday. On the prayer of learned counsel for the private, on the prayer of the learned senior advocate for the private respondents, the matter is adjourned till May 4, 2023.
— 29.
Nobody else is there.
Already there is a order is passed.
In your favor?
In my
It's
favor,
subsisting.
there was a direction for filing affidavit. Affidavits are exchanged. Matter is ready
Ready.
for hearing.
I'll grant only adjourned for the day then.
Then
Try to give a notice to them, Mr. That
I will, my
it
lord.
appeared today. When should I keep it? Tomorrow or day after? Day after cannot be. I mean,
Tomorrow, my lord.
tomorrow I'll keep it. None appears for the respondents, although the petitioner is represented through counsel. Full stop. Let the matter stand adjourned till tomorrow.
23, I was for the petitioner.
Whatever happened. I have recorded an order, probably none appeared. So nothing to do. List the শেষ, list over. এটাতে ডাকতে বলছিলাম তো। এই তো দেখলি হিয়ারিং। একটু পড়তালার বুঝছি না।
Item the 28 stated here.